editing so that they can do it. Yes, please.
May it please your lordship. With the consent of the other side, I beg to mention item number 28.
Item number?
28. Kindly be adjourned for the day.
The last matter on the board.
Yes, lordship.
Why? It's an 18 matter.
Lordship, personal difficulty regarding to this item for today.
What is the personal difficulty? 18 matters. You are there.
No, lordship, my name is not there.
C. Chaudhary, R. Borthakur.
They are my seniors.
So they are there.
It's conducted by A.M. Bora, lordship, senior counsel. Personal difficulty.
When do you want?
Any day, lordship, pleases.
Hmm?
Any day, your lordship, pleases.
Wednesday.
Next Wednesday.
Mr.
M.S. Hussain.
M.S. Hussain, Learned Counsel, seeks accommodation on the ground that Mr. A.M. Bora, Learned Senior Counsel, appearing for the petitioner, is having personal difficulty today. Stop. The matter pertaining to the year 2018, this court, by way of a last chance, allows the prayer and a prayer. Stop. List on. When do you want it?
Any day, lordship, pleases. Lordship. Next week.
Not next week. It will be called Hekor did you?
After 2 weeks, lordship. Then.
No 2 weeks. A 2 week or last did you? Thursday. 3, 4.
Lordship, next week, lordship.
Okay, next week, Monday.
May I please, your lordship? My lord, this is a joint prayer with regard to item number 6 and 7. It's a similar request on.
It's an admission. It's in the admission. Let us see if something can be done. We can just wait, Mr. Dhar.
Madam. Because on this, I'm led by Mr. A.M. Bora.
All right, let us just have a look at for admission.
Definite.
Because you see, seeing the people who are all gathered for mentioning, looks like my board is going to get over only.
Definitely, we'll be there.
So don't make a mention for the admission matters and the order matters. Hearing, if anybody has a difficulty, please make a mention. Let us have the files called. We will accommodate if required.
My lord.
I beg to mention item 10 and 11. In item 11, I am appearing for the appellant, and item 10, my sister is appearing.
10 and 11 is an order matter.
Yes.
I have just said don't mention.
My prayer before you
Please wait. Let the file be called.
Only for paper book.
Wait for your turn, Mr.
Because
Yes.
I have some other matters in outside my lord.
Sorry, that is not the problem of the court. That is for you to see how you will accommodate yourself for the day. Sorry, it's an order matters. Please don't make mention. Make sure your junior is there. Yes.
Please, your lordship. Lordship, I beg to mention item number 23, lordship. It's a hearing matter 2012. Lordship, pass over for the day.
2012.
Pass over for the day only, lordship.
No, but what is this matter?
This is revision against
392 IPC.
lordship. Conviction of 3 years, lordship. Revision against
It's
conviction
a
of
12th matter. You're on bail.
yes, lordship.
It can't go on like this. You wait. We'll see the order. Wait. You are for the petitioner?
I'm for the petition. lordship.
You have a look at the file.
Yes.
May I please, lordship?
Yes.
Item number 27. Lordship, kindly this matter be adjourned for today.
20?
7.
Why?
Lordship, due to lack of communication with the petitioner.
What communication you need? The order, let us see. Wait for your turn. Look into the file. You have the file or not? Have a look, the impugned order and the grounds taken. You read. Yes, Mr.
May it please, your lordship.
Vaidya?
Lordship, this is a quashing of an impugned order of framing charge against the petitioner, my lord.
Under 468-471.
No, my lord, the
charge was ultimately framed under section 417, my lord, simple
Four?
cheating. 417 of the IPC,
417.
simple cheating, my lord. The punishment extends up to 1 year. And the offense is compoundable at the behest of the, my lord, the informant or the person who is alleged to have been cheated, my lord. So, my lord, the matter pertains to one NIT, which supposedly was not published in the Gazette and official newspaper as it is supposed to be. However, my lord, that communication was erroneous, and subsequently, my lord, that uncontroverted document has been placed on record before your lordship at page number 19 to 22 that the DIPR was duly informed.
Where
And
is
by
the
the-
complaint?
Lordship, it was an FIR, my lord.
Where
The
is
FIR is at page
FIR?
number 25, my lord.
Page number?
25, my lord.
You are
25?
appearing for the informant.
My lord, my learned friend is appearing for the informant.
25 is contents.
My lord, the content starts from page number 27.
Yes, please read.
Constable, may I take your lordship, my lord. To the officer in charge, Lakhipur Police Station, the complainant happens to be one Anisul Rahman, represented by my learned friend here, my lord. Sir, most respectfully, it is stated that the Lakhipur Town Committee has informed the general public, the Deputy Commissioner, Walpara District, and the Circle Officer, Lakhipur Revenue Circle, that they have published the tender notice amounting to cost of rupees 1415.17 lakh for 4 number of works under this work order of Lakhipur Town Committee in Doinik Agrodut and the Assam Post in the issue dated 19/5/2013. So 19/5/2013 newspaper, this was supposedly published, my lord. But this line is pivotal, my lord, the next line. But no such tender notice from Lakhipur Town Committee was seen printed in the above mentioned newspapers in the issue dated 19/5/2013. It is worth mentioning that the chairman of Lakhipur Town Committee, which happens to be the petitioner before your lordship at this instance, in collusion with some employees of the committee, without giving any notice to the aforesaid 2 newspapers, has cheated the general public, the Deputy Commissioner, Walpara District, and the Circle Officer, Lakhipur Revenue Circle, by manufacturing 2 tender notice. It is to be mentioned herein that there arises several irregularities and corruptions in the work conducted by the Lakhipur Town Committee. It is therefore prayed that your honor will stop the tender to be held on 28/5/13 and take necessary action. It is our simple prayer.
Where is
before
the
your honor.
cognizance? You are challenging the cognizance.
I've challenged the, my lord, the
Framing
order
charge.
framing charge,
Where
my
is-
lord. My lord, the order framing charge, the impugned order, which, my lord, in my simple understanding, doesn't happen to be reason, my lord, at page number 69, my lord. This is the last page of the petition, my lord.
There is no application of mine, nothing.
No reason order, my lord. And my lord, why, my lord? Most importantly, my lord, if your lordship goes to annexure 2, page number
What were the
18
materials?
and 19 to 22, my lord, those newspapers have been annexed, my lord.
Page?
My lord, page number 18, my lord.
No, even, Mr. Counsel,
Okay.
you see, notwithstanding whether the newspaper, whether these were published, not published.
Okay.
How a case of criminal case is made out? This is a pure civil case. You could have gone to a writ court also if you wanted.
Lordship, may I submit, Lordship? Lordship, yes, Lordship correctly said that it may be read court. Therefore, before this criminal petition, Lordship.
You know,
this-
for a, you see, if you.
Yes, sir, you
for an
approach it court, sir.
FIR, for a criminal sections to be attracted, there has to be criminality, which has to come out from the complaint and the materials collected, right? Now
Lordship,
here, admittedly, let us assume that your allegation is correct. You are saying that the petitioner and that society, right?
My lord,
this
Lakhipur
is-
town
The town
committee.
committee has published 2 tender notice for some work.
Lordship,
Later on, it was found that these 2 tender notices were never published.
Lordship,
Correct?
Right.
This is only your allegation.
Lordship.
Even if we assume this allegation correct, what is the criminality involved here?
Lordship, assuming the correct Lordship, I have proposed before the read court, Lordship. Lordship, like to say, Lordship, in my affidavit, Lordship, there is a judgment of the read court, Lordship. Lordship may, in my affidavit, Lordship.
What happened there?
that happened, Lordship, there is a judgment, Lordship, passed by all the deeds, Lordship, which has been happening at no advertisement, no equipment. Before that, Lordship, an inquiry report was there.
No,
From
what
the
happened
government side.
before the writ court? Finally, that is pending or it is over?
Yes, Lordship, finally it is that before pertaining with the case, I place on record the displeasure of the court in not taking any development in departmental action against the FIring officials
Correct.
indicated
Correct.
the inquiry report referred
Correct.
to above. It is so shocking as to how the NIT could be shown published.
There's
Only.
nothing wrong in that.
Yes, to
That-
take immediate steps, Lordship.
Correct.
Lordship.
You have taken criminal step, but this court is only concerned with that.
Lordship.
Now, in order to attract the criminal sections or to make a criminal offense, the ingredients of those offense has to be there.
Lordship, it was
But
directed
What
to
is the deception?
It is rather their case only, my lord, that it was published in one newspaper. These are departmental
Maybe
measures, my
what
lord.
you're saying is correct.
Lordship.
Absolutely. But you have your remedies for that.
Lordship,
Mr. Vaidya, what are the materials?
My lord, apparently,
On basis of what materials was the charge framed? Where are the materials? Where
my
are the
lord, there is
evidence?
nothing, my lord. I'll run your lordship through my lord, the charge sheet, my lord.
Yes.
Because there happens to be the concise report of what
Yes,
the IO
please.
has found during
Let's
this.
go there, page
And my
51.
lord, that surprisingly, my lord, page number 61, this starts, my lord, the charge sheet.
Yes,
My lord, at page number 62 in the third column,
yes.
the petitioner before your lordship is the only person who has been sent up for trial, my lord.
Anisu Rahman,
No, my lord, he happens to be the informant, my lord.
who
my
is the
learned friend.
petitioner?
My lord, the third column, Rajesh Prasad Gupta.
Hmm?
He was the chairman of the
Rajesh
town
Prasad.
committee.
Chairman of the town.
Town committee, and my learned friend's client, my lord, he did not notice any newspaper publication cut out in the notice board, and hence, my
You
lord,
see, at this
proceeded with the
stage,
FIR.
unless the materials collected by the prosecution show that there was a publication, this court will not be going into that. This court will assume that all these materials that has been collected by the prosecution is correct and test whether they are sufficient for a conviction or
Yes,
not,
my lord.
without before it is cross-examined.
My
That
lord.
is all.
My lord.
That is the test.
Yes, my lord.
Correct.
Correct, my lord.
This is a test, I think, just long back, Justice Krishna Iyer in one of the decision had.
Yes, my lord, that is there, and
laid
plus, my
down.
lord, subsequent to Bhajanlal also, my lord, every year this has been reiterated by the
Bhajan Lal
MS
is
court,
of
my
course
lord.
quashing, but
They wasn't.
on framing charge
With
and
regard to
discharge,
framing charge also,
I
yes,
think
my
there
lord.
is a decision.
That the
of
application of mine ought to be
78, I
there, my
think.
lord. Application of mine, my lord,
Correct,
that is
correct.
primary, my lord.
So where is that? Now you show me what was there before the trial court.
So, yes, my lord. Page number 62, my lord, this
Please
FIR
read.
starts, my lord.
Please read.
Page number 62, my lord, to up to page number 63, my lord, these are the allegations of the FIR only. So page number 63, my lord, will start from the second paragraph, during, the word during, my lord.
Yes,
Got you found it?
yes.
During investigation, the place of occurrence was visited, the statements of witnesses were recorded, and necessary documents were seized and sent to FSL Guwahati for examination. And after examination, the reports were collected. Accused, this person was arrested and forwarded before the honorable court. FIR named accused Uttam, this person applied for pre-arrest bail, which was rejected by the honorable Guwahati High Court. But he was not arrested in connection in the instant case, as no material was found against him. Sufficient materials have been established against accused Rajesh Prasad Gupta from the statements of witnesses and FSL reports, etc. And as such, under
Where are
charge sheet
the
under-
statements?
Lordship, those are also annexed, my lord. I'll take your lordship through.
I've read it. Let's go.
468, 471 is
I've
made
read
out, my
it.
lord.
I've read it. Mr.
Cheating, my lord. Sorry,
I've
the
read it.
offense of cheating is not there. This is for forgery. But
I've
the
read it.
learned court, my lord, after going through the, my lord, statements of the witnesses, did not find any material of either forgery or using a forged document, but simple cheating, my lord.
Yes, where are those statements?
My lord, I'll take your lordship through the statements. My lord, page number 34, my lord.
Mr. Counsel, you take your seat. I have only expressed my mind so that you are prepared in that manner to give reply. Yes, Mr.
Yes,
Vaidya.
sir. This is the statement of the informant, my lord. My name and address are as given below. I am aged 40 years. I am a businessman. At about 10 a.m. on 24/5/2013, my friend Sonwar Hussain informed me over phone that notice inviting tender for 4 work of rupees 14 15.17 lakh of NCPR 2004-2007 under Lakhimpur Town Committee has been published.
His friend has informed,
His friend has informed.
and this friend is not not an accused.
No, my lord. This friend probably he was an interested tenderer, my lord, but
No,
on
because
record,
why I'm
not stated.
asking, you see, the information given to him is through his friend, not
Yes, my lord.
not you.
Not my lord. Not,
It is not that
not-
you have deceived. How can it,
yes, my lord.
yes.
That is there, apparently there,
Yes.
his statement only. Right. I went to the office of the Lakhimpur Town Committee. When I asked Rajesh Prasad Gupta, that is the accused before your lordship, the
Yes.
chairman of the town committee, about the terms and conditions of the tender, he told me that the advertisement with the terms and conditions has been published in Doinik Agrodut and the Assam Post dated 19/5 this. Subsequently, at about 8:30 AM on 25th January, my friends, this, same gentleman and two others, gave him copies of Doinik Agrodut and the Assam Post published on 19/5/13. But as the advertisement published in the newspaper and the one given by the town committee were not in conformity on 25/5/13, the copy of the Doinik Agrodut dated 19/5/13 was shown to the Deputy Commissioner, Gwalpara District. The Deputy Commissioner asked for copies of both the newspapers, and at 11 AM on 27/5/13, we gave the newspapers to him. In the meanwhile, 25/5/2013, I lodged an Ejahat before Lakhimpur PS with request
no
for an
case.
investigation in this regard.
There's
This
no
kind of-
criminal case. Yes, 35.
And my lord, 35, same my lord.
Who is Abdul Matin?
My lord, apparently, my lord, his friend, because his name appears in the previous statement at page
The
number
sec-
34.
Okay,
He just accompanied the informant, my lord, doesn't hold any post there.
yes, read my name.
My name and address are as given as below. I am aged 33 years. I am a businessman. At about 11 AM on 28/5/13, I went to the office of Lakhimpur Town Committee with regard to certain works under RTI. When I had a look on the notice board, I found that there was a tender on 28/5/13. When I asked the chairman of the town committee about the tender, he replied that the advertisement inviting tender was published in Doinik Agrodut and Assam Post newspaper on this. Then Agrodut and Assam Post were not in circulation in Lakhimpur locality. This is his given file that probably is that newspaper doesn't come to his home. When I asked the chairman of the town
When
committee,
I had what he said.
then Agrodut and Assam Post were not in circulation at Lakhimpur
circulation
locality.
at Lakhimpur locality.
Not publishing is something else, my lord, if I don't send it.
Yes,
So
please.
the allegation not that. In the notice board remained signed on 16/5/2013, and white remained hanged in the notice board with fresh raw glue not dried up. The chairman Rajesh Prasad Gupta picked up an argument with me and told that it was hanged on 16/5/2013. Then I asked for copies of the newspaper in which the notice for tender to be held on 28/5/13, and under his instruction, Uttam Sarkar, head assistant of the office, gave me 2 copies of the advertisement. As a suspicion
All
due
right.
on me, I
Alright,
talked
next.
this. Rest of the witnesses, my lord, there are no intimidating remarks upon, my lord, the present
Alright,
petitioner, my lord.
Alright,
They have not even whispered his name, my lord.
alright.
Same, my lord. I think my learned friend would also agree. Then, my lord, I will not take your lordship through this, my lord. Otherwise, my
Now,
lord,
no, but there are some materials which are in support of you. Why you want to skip?
my lord, for that, my lord, I would prefer to take your lordship through my lord, the most uncontroverted document which is there on record, my lord.
One
Prior to
second,
going through the
one
statements of 336, my
one
lord.
second.
For that, my lord, I beg your lordship's attention to page number 18, my lord.
Yes,
This has been issued by the Director of Information of Public Relations, Assam Dispur, my lord.
Hmm.
And my lord, this clearly states, my lord, that these 2 tenders, my lord, they were asked by the concerned Lakhimpur Town Committee to be published.
where, where it
Lordship
said-
would see page number 18 first, to whom it is addressed. It is addressed to the advertisement manager of the Assam Tribune, Assam Post, and Doinik Agrodut.
Hmm.
These 3 newspapers,
To requested to publish in one issue of your newspaper. Yes,
this is the thing, man. And this is not that, my lord, I am a maker of this document, my lord. This has been sent to the advertisement manager of these three
All
newspapers,
right,
and by
next.
whom, my lord, the director. So if such a tender exists, my lord, what the town committee would do? Town committee would send it to the, this is not a personal cost, would send it to the DIPR. And it is the DIPR's prerogative in which newspapers they publish it. The DIPR deemed fit to be sent to Assam Tribune, Assam Post and Dainik Agradut. And consequently, Assam Post and Dainik Agradut published it. This is the prerogative of DIPR, my lord, the directorate which sits in Guwahati, my lord. So once this is proved that I have done my due, my lord, I have
Yes,
sent
now, the prosecution witness Mujamil Hussain have said that it was published in Dainik Agrodut on 19/5,
19/5,
but
my lord.
not in another paper.
He's probably not seen it, my lord.
Whatever, Mr. Vaidya, this court is with you.
Yes, my lord, understand that, my
You
lord.
see, it is not that it was not, whether it was there or not, that is immaterial,
My
but it appears that the prosecution witness
Witness
is also
himself
saying that it
stated.
was there in one paper.
Yes, my lord.
Correct?
Yes, my lord, that is there.
So that is in your support.
Yes,
Now,
my
where are
lord.
the materials for cheating?
Yes, my lord, that is not there.
How
That is why
cheating has been
primarily
framed?
my ground, my lord. That the
It is
417 is not
absolutely missing.
attracted, my lord.
Yes. Now come to the next, Anwar Hussain, because
Anwar
these are
also same, my lord.
prosecution witnesses.
So, my name and address are given as above. I am businessman. I am aged about 50 years. On
He's also said published notice inviting
Published
tender
notice,
in only one
only
newspaper.
one newspaper, my
So
lord. That
they
is
both
stated out, my
are
lord.
saying it has been published.
Same with my lord, Dilip Kumar Nath, my lord.
He is also
Page
saying, I did
38,
not
my
receive
lord,
any
Dainik
press
Agrodut dated
notice
19/5,
from
my
so
lord.
and so, hence it was not published in Dainik Agrodut dated. I don't know if anybody published. There are no materials.
Next witness also same, my lord, page number 39, my lord. He speaks about the Dainik Agrodut publications, my lord. Then, my lord, next important witness here, my lord, is page number 41, my lord. Sri Jayanta Bora, my lord. This would clear any residual, my lord, anxiety that this honorable court might have, my lord. May I read, my lord? Page number 41. My name and address are as
Anyway,
given above.
41. Yes.
41, my lord. I am aged 34 years. I have been serving as liaising officer, advertisement section in the office of director, information and public relation, having received the prayer white LTC letter dated 16/5/13 from the chairman, Lakhipur Town Committee, Gwalpara district, to publish advertisement inviting tender for work of Lakhipur Town on 19/5/13 in compliance with the instruction from the director Ranjit Gogoi. I forwarded the press notice inviting tender to Ramesh Chandra Talukdar, the superintendent of our office, by this dated 18/5/13 to
So
send
this is
the press
that
notice.
that document which you have shown at
That
page
document
18.
which I have shown, my lord. He is the officer from the Director of Information of Public
So
Relations.
these are prosecution witnesses.
Prosecution witnesses, he said that they have received, my lord, for publication, and he has accordingly deliberately forwarded to the newspapers, my lord.
Yes.
Sent the notice
Anything
to
else?
Assam Tribune, Agrodut, and this, my lord. This,
Anything
my lord,
else?
clearly puts everything, my lord. It has been stated that DIPR has received notice from my office.
In fact, the
publishing
Ramesh
advertisement.
Chandra also
Taluk, the
supports.
same, my lord. Yes, my lord.
He supports.
He supports, my lord. From the same DIPR office, my lord. And these gentlemen, they are not accused persons, my lord. Is that there is any collusion between me and them? And 43 also same, my lord. This is the press research officer, my lord, of the DIPR office. Then, my lord, page number 44, my lord. From the newspaper, my lord,
Hmm.
where it was published. Shri Kailash Chaudhary.
Page
Yes,
44.
page 44, my lord.
Hmm.
And from the other newspapers, my lord, no witnesses have been examined, my lord. Dainik Agrodut or Assam Tribune.
But the
But this
newspaper
gentleman-
says that they have not received.
They have not received, but they have not received from DIPR, my lord. Once our responsibility ends, once it is sent to the DIPR. I am not
Yes.
authorized to send to the newspaper directly.
Cheating. What are the ingredients?
Lordship, in my affidavit, Lordship, affidavit reply,
We'll
Lordship.
come to your affidavit
Lord-
first.
Page number 7, there is an inquiry report by the government. Lordship.
417, punishment for cheating.
Cheating.
415. Read 415 first. I'll come to the facts. First 415.
Lordship, whoever by this deceiving any person fraudulently or dishonestly induce the person to be deceived to deliver any property to any person or to consent that any person shall retain any property or intentionally induces the person so deceived to do or omit to do anything which he would not do or omit if we are not deceived.
Where are these ingredients, Mr. Counsel? What is the deception? What is the inducement? What is the property delivered? What is done? What is not done?
Right.
Where are these ingredients?
Lordship, therefore, the inquiry was conducted by the department.
Mr. Counsel, inquiry conducted.
In the writ petition also, in the-
Is appreciated.
Lordship,
If anything is there, it would be for disciplinary action, not criminal action.
Lordship, for
This FIR is filed in 2013. It appears it is not in good taste. It doesn't appear. Yes, from affidavit, what you want to show?
Lordship, kindly page page number 10, Lordship.
You see, for every action, you cannot go before the
Sorry,
criminal court.
Lordship, please, for my objection, Lordship.
You
Lordship, may
have to
record.
make out an offense in the materials that are available.
Yes.
Uncontroverted material, taking the materials to be true.
Page number 10.
None of the ingredients of cheating by no stretch of imagination is made out in from the statements and from the FIR. There is no deception, nothing. In fact, in the complainant, he and his friend, they say we suspect he is going to misappropriate. This is the allegation. They suspect.
That allegation has been proved by the department. Lordship, kindly see the page number 10.
All right, page
Number 10.
number 10.
Only findings. There's a detailed inquiry report by the government, Lordship.
Yes.
Page number 10, Lordship.
This inquiry
see,
was not
I-
before the trial court at the time of framing charge.
My lord, this is-
Before. 10, that was, Lordship.
Was it before, was it available in the materials or not?
my lord, from the charge sheet, it doesn't appear.
It does
to be
not
so, my lord.
appear.
Does,
Then how
Then
can
7,
the
8,
court
30.
look into this? Because
Seven,
this
This
is
is
not
a
one
complete
of
separate
the,
proceeding, my lord.
7, 8, 13.
Department.
huh?
7, 8, 13, the inquiry report was.
7, 8, 13 is after or before?
7, 8, 13. After subsequent, my lord.
After,
Incident is of the month of May, my lord.
huh?
Incident, my lord, the alleged incident.
No,
is
no,
of the
charge
month
sheet
of May,
file
my lord.
when?
Charge sheet, my lord. I'll just provide the date of the charge sheet, my lord. Date 61. The date of the charge sheet is, my lord, 22/12/2014, my lord.
22?
12/2014, my lord.
Charge sheet is after.
After, my lord.
Now, is this report, inquiry report part of the charge sheet?
No, my lord, doesn't appear to be so, my lord. Absolutely no whisper about this inquiry report.
All right, read, you want to show? Let me see
Lordship,
what is there.
Lordship, page number 10, Lordship. Lordship, paragraph number 3, subsequent paragraph 1, Lordship. Findings from the, it appears that newspaper advertisement of the NLSPR project for an amount of rupees 14 crore 15 lakhs was not published in the Assam Post and Dainik Agadut. One copy of it was collected in the office of the town
No,
committee.
right, now where is that order of the High Court?
Lordship. Order of the High Court, Lordship, starts details from page number 16, Lordship. In this High Court order, Lordship, everything and on the basis of inquiry report, all are discussed, Lordship, how they are cheated, they have been cheated by without NIT, Lordship. The long judgment, Lordship, and page number 31. And High Court was shocked and surprised how these are going on, Lordship.
High Court records its displeasure
Yes,
in not taking any departmental action
Yes,
against the
yes,
hearing officers.
Lordship,
I do not disagree with this,
Lordship.
but what have you done? You've put a criminal action on motion on the
High Court
basis
is-
of which charges have been framed under section 417 when there are no ingredients whatsoever of cheating.
This I am
Later-
informed, Lordship, but I am
I am-
informed, Lordship, it was the duty of the prosecution, Lordship.
There was no reason for you to in fact file an FIR. It is an abuse of the court process. Where
My
is
lord-
the criminality?
Rather, my lord, this honorable High Court is rather clear in paragraph 46, my lord.
Yes, I have read paragraph 46. It is in front. It is also shocking as to how the NIT could be shown published as to avoid and to confine the same to a few favored ones. Direction is hereby issued to take immediate steps to unearth the racket and also to take departmental action against the hearing officers. This is the order of the High Court.
And page number 33, Lordship, all the details were discussed, Lordship, in High Court.
You see,
ordered that.
Mr. Counsel, is there any
Lordship,
difficulty?
lapse is there, Lordship, I am admitting, Lordship, as a
The
informant, I can't do.
conclusion is
Yes.
before us.
Yes,
Tara?
para 33, Lordship. Page number 33, Lordship.
What has happened to the proceedings?
Nothing, Lordship, I think.
There is a
Nothing,
stay.
no, subsequently, my lord,
no,
when this petition was filed before this honorable court, my lord, owing to the prima facie materials on record, my lord, the proceedings were stayed. my
The
lord.
person was state, Lordship. Lordship, if he is innocent, he may face, he will be acquitted from this, from the very first day, Lordship. That is my submission, Lordship.
Anything else?
And Lordship, that is my.
I'm quashing it.
Obliged, my lord.
Yes, take it for final disposal. Heard Mr. D. Vaidya, learned,
D.K. Boydo, my lord.
D.K. Vaidya, learned counsel appearing for the petitioner.
Petitioner, my lord.
Stop. Also heard Mr.
D. Mohanta.
D.
Mohanta.
Mohanta, learned counsel appearing for
R2, respondent.
respondent number 2 stroke informant. And yes, Ms. Bora, and Ms. S.H. Bora, learned APP for the state respondent. Stop. By way of this petition under section 482, read with section 401 of CRPC 1973, the petitioner is seeking quashing of the impugned order dated 10/7/2018, whereby charge under section
417.
17 was framed against the petitioner, and the charge sheet number 274/17 and the proceedings thereof in connection with GR case number 1012/2013 pending in the court of learned additional Chief Judicial Magistrate Gwalpara. Stop. The facts of the case is that a project, within quotes, construction of 4 numbers, a project to me page 3 paba. Page number 3, paragraph 3, murder tick mark code is A. Taking you till donor. Tarpisot. Thereafter, paragraph 4, B to B. Give me 1 second. Where is that FIR, Mr. Vaidya?
FIR, my lord, page number 25, it starts. The operative portion starts at page 27, my lord.
27,
my lord.
The facts of the case is that the respondent number 2 stroke informant by FIR dated 25/13. No. Is it 25? Date
Date, lordship would find that the receipt and register, my lord.
26/5/2013.
26/5/13, page 25.
Allegedly informed that the Lakhipur Town Committee has informed the general public, the Deputy Commissioner Gwalpara District and the Circle Officer, Lakhipur Revenue Circle, that they have published the tender notice amounting to cost of rupees 1415.17 lakh for 4 members of works under page 27 underline with quotes in Dainik Agrodut and in the Assam Post in its issue dated 19/5/2013. But however, no such tender notice from Lakhipur Town Committee was seen to be printed in the above mentioned newspapers in the issue dated 19/5/2013. Stop. it is accordingly alleged that the chairman of the Lakhipur Town Committee, I, the petitioner, in collusion with some employees of the committee, without giving any notice in the aforesaid two newspapers, has cheated the general public, comma, the deputy commissioner, comma, Gwalpara district, and the circle officer, Lakhipur Revenue Circle, by manufacturing two tender notice. Stop. Accordingly, the said FIR was registered as Lakhipur PS case number 265/2013 dated 26/5/13 under section 120B, 465, 468, 471, 420, 409 IPC. Stop. Thereafter, investigation was carried out and charge sheet was submitted on
22/12/14, my lord.
where do I get that?
My lord, at page number 61.
On 20. What is the date, Mr. Vaidya? On
My lord, at page number
22/12/14.
14, my lord.
22/12/14 or 26/5?
No, my lord, that is the date of the FIR, my lord.
On 22/12/14,
12/14, my lord.
white charge sheet number 274/24.
14, my lord.
Sorry, 14. Huh?
My lord.
Stop. Upon the aforesaid charge sheet being submitted, comma, the trial court by order dated 10/7/2018 framed charge under section 417 IPC against the petitioner and accordingly issued summons to all the prosecution witnesses. Stop. Situated thus, the present criminal quashing, present petition has been filed for quashing the aforesaid order dated, aforesaid order dated
10/7/18, my lord.
10/7/2018, passed by the trial court, framing charge against the petitioner. Stop. Mr. D.K. Vaidya, learned senior learned counsel appearing for the petitioner, submits that no material, no criminality can be said to be made out in the face of the materials collected by the prosecution in support of the prosecution case. He further submits that it is also apparent from the materials collected by the prosecution, especially the statement of the witnesses who are employees in the
My lord, Directorate of Information and Public Relations.
Directorate of the
Information and
Public Relation Office,
Dispur, Guwahati.
Dispur, Guwahati, that the petitioner had
Duly sent advertisement.
forwarded the advertisement in advertisement in question, forwarded the advertisements in question to be published in the newspapers.
Newspaper.
Stop. He accordingly submits that the continuation of criminal proceeding against the petitioner is totally unjustified. Stop. That's right.
My lord,
Per contra, Mr. So-and-so learned,
D. Mohan.
Mr. Mohanta, learned counsel for the respondent number 2 stroke informant submits that the inquiry held by the who has held the inquiry?
And-
By the
and-
Secretary to the Government of Assam Urban Development Department
Lordship.
in connection with the anomalies in Lakhimpur Town Committee clearly reveals that the petitioner has committed illegality while discharging his duties under as chairman,
Chairman.
as chairman of the Lakhipur Town
Town.
Committee. Stop. He further submits that he further submits that in view of the inquiry reports, the criminal proceedings ought not be scuttled. Stop. Correct.
Lordship.
I have heard peruse everything Koidiba. Tarpisat lekha.
My affidavit, para 9-10, Lordship.
I'll come to all. Apt at the outset to refer to the contents of the subject FIR, which reads as hereunder. Page 27. Page 27, A to A. Okay. Reading of the aforesaid FIR, it appears that the allegation against the petitioner is that the tender is that the advertisement in connection with the subject tender could not be found in the two newspapers as claimed by the petitioner. And in that view, it is stated that the petitioner has cheated the public
Lordship.
and the district administrations.
Lordship. Well,
It further appears that on the basis of the aforesaid allegation, the investigating the jurisdictional police station registered the case under section 120B, 465, 468, 471, 420, 409 IPC against the petitioner. It further appears that the investigating officer has recorded the statement of the witnesses during investigation. Stop. It appears that the complainant apt to refer to the statement of the complainant Anisur complainant stroke respondent number 2, which reads as hereunder, page 34, A to A. Apt also to refer to the statements of Abdul Mateen, who is a friend of the complainant, which reads as hereunder, A to A 35. No, A to A 35. Muzamil is not required.
We'll leave it to your lordship, my lord. Repetition.
Okay. Apt also to refer to the statement of Muzamil Hussain. Who is he? He's also a friend.
My lord,
Who is-
appears
who
from
is
the
also-
informant
who is
statement. my
another
lord.
friend of the
Informant.
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 A to A 36. Apt also to refer to the statement of Sanohar Hussain, who is a businessman. Which reads as hereunder, A to A, page 37. Reading of the aforesaid statement of the prosecution witnesses, it appears that two of the prosecution witness, no, it appears that the complainant it appears that that FIR to, oh sorry, complainant. It appears that on 24/5/2013, one of the complainant friend, Sanohar Hussain, who is not a listed witness, Sanohar Hussain, informed him over phone that notice inviting tender for the subject work has been published with certain terms and conditions in the office of the town committee. And accordingly, he went to the office of the town committee where he met the petitioner, who explained him the terms and conditions of the subject tender and has also informed him that an advertisement has been published in this regard in 2 newspapers. It appears that, however, upon checking the 2 newspapers, it appears that no such advertisement was seen. In this backdrop, it was alleged that the petitioner is suspected to misappropriate the money by committing forgery or fraud. It further appears from the statement of Abdul Mateen that the 2 newspapers in question were not in circulation at Lakshipur locality, where the respondent number 2 resides. It further appears from the statements of Muzamil Hussain and Sonowar Hussain that the tender notice was published in one of the newspapers as claimed by the petitioner.
My lord, one small interruption, my lord. Lordship possibly had observed that the informant was informed by his not listed witness, Sanohar Hussain.
I did not say
My
that.
lord, my lord.
I
He is a
didn't.
listed.
But where is Sonowar Hussain statement?
Lordship would find it at page number, my lord, 37.
It further appears that Sonowar Hussain, who is claimed to have informed the complainant as regards the subject advertisement, has stated in his statement that the said notice was published in one of the newspaper. It further appears from the statements of, where are those people?
My lord,
Of,
those statements
of-
start from page number 41,
of
my lord.
of Sri Jayanta Bora
Ramesh Chandra
42, my lord.
and there are three, no?
Yes, my lord.
Comma, Ramesh Chandra Talukdar and Lojit Rabha, who are employees in the office of the Director Information and Public Relation, that they have received the prayer dated, that they have received an application dated 16/5/2013 from the petitioner to publish advertisement inviting tenders for works of Lakhipur town on 19/5/2013. Stop. It further appears that the aforesaid application was thereafter sent to the superintendent of their office to forward the same to the press for publication thereof. Apt also to refer to the said application. Apt also to refer to the letter dated 18/5/2013 enclosed as Annexure 2 to the petition issued by the Director of Information and Public Relations, Assam, Dispur, Guwahati, to the advertisement manager of the Directorate of Information and Public Relation, Assam, Dispur, Guwahati, requesting to publish the enclosed publish these advertisement in question in one issue of their newspaper.
My lord.
Correct?
My lord. Well, to the advertisement manager of these three newspapers, my lord.
Oh, sorry.
Top mention.
To the advertisement manager of the of three newspapers.
My lord.
Of three newspapers being the Assam Tribune, Assam Post, and Doinik Agrodut.
My lord.
It appears that based on the aforesaid information, it appears that thereafter the investigating officer by charge sheet number 274/14 dated 26/5/13 submitted charge sheet against the petitioner under section, where are the sections?
Lordship would find it at page number 65, my lord. Hold on, sir.
Under section, page number 65, under section 468/471 IPC. Stop. It further appears from the relevant portion of the charge sheet is extracted hereunder for ready reference, page 63 A to A, huh? Okay. Thereafter, it appears that the trial court by order dated 10/7/2018 framed charge against the petitioner under section 417 IPC. Stop. Apt to refer to section 415 of IPC, which reads as hereunder, quote unquote, apt also to refer to section 417 IPC, which reads as hereunder, quote unquote. It is settled law that the offense of cheating is established when the accused thereby induces any person to deliver any property or to do or to omit to do something which he would otherwise not have done or omitted. Now, in the present case, even if the materials collected by the prosecution is assumed to be true in its face value, before the cross-examination, comma, the same cannot be said to have made out a case of cheating against the petitioner. Apt at this juncture, to refer, and pertinent that the respondent number 3 complainant, writ petition was filed by whom?
Filed by us, my lord.
You have filed
Yes,
for
my-
what?
yes, my lord.
Pertinent that upon the petitioner being removed as the chairman of the Lakhipur Town Committee, Gwalpara, comma, you had challenged that removal.
That something.
The same was challenged before this court in WPC 7177 of 2013, wherein this court by judgment and order dated 25/3/2014 was pleased to dismiss the said writ petition by observing as hereunder, page 46, para 46, A to A. The argument of Mr. Mohanton Lanet, counsel for the respondent number 2 complainant, to the effect that it has clearly come out from the inquiry that the petitioner has committed illegality while calling for the tender in question, and therefore a criminal case is made out, is totally fallacious. Stop. Before putting criminal action in motion, it is imperative that the materials collected by the prosecution discloses a criminal offense. Otherwise, it would be sheer abuse of the court process. In the present case, as indicated above, it is apparent that no ingredients of cheating whatsoever can be said to be made out against the petitioner, even assuming the allegations to be true in its face value. That being so, this court is of the unhesitant view that continuation of criminal proceeding against the petitioner is absolutely unjustified, and hence the order of the magistrate framing charge, order of the magistrate dated 10/7/2018, framing the impugned charge against the petitioner cannot is totally illegal and erroneous. Stop. Accordingly, the order dated 10/7/2018 of the learned trial court stands set aside and quashed. Resultantly, the proceedings in connection with GR case number 1012/2013 pending in the Court of Learned Additional Chief Judicial Magistrate, Gwalpara, stands quashed. Interim order was there,
Interim order.
that will merge,
My lord,
disposed of.
Deeply obliged, my lord. Obliged.
Yes,
Please, your lordship. This petition is referred to the judgment and order dated 7/12/2018, lordship,
against,
against conviction of the petitioner, whereby in a NI case, lordship, whereby the accused person is sentenced to pay a fine of rupees is 3,60,000 and in
where,
default
against which order?
against the order dated 7/12/2018.
This is a revision petition.
Revision petition, lordship. Both the congruent judgments are against the petitioner, lordship.
On what ground?
Lordship, here, the notice, lordship, which is mandatory, lordship. And the notice served is defective, lordship. Notice served on me is defective.
Notice served is
Served is defective, lord,
defective.
defective.
What is the defect?
Defect is that, lordship, page 23 is the complaint, page 22 complaint petition, lordship, para 5.
Will that make the entire case of the prosecution fatal?
Fail, lordship. Prosecution, it will not make the entire case, but several other grounds are also there, lordship. Because in the
Which is the
meantime,
other ground?
also in the meantime, the accused person has paid an amount of rupees 1,20,000.
Hmm?
1,20,000.
Hmm.
So that should have been adjusted,
That
And-
should have been,
lordship, set off, lordship. And lordship, here in the complaint petition, 2 persons has been made accused, lordship. And it is said that both the accused persons were similarly situated persons and liable. Page 22 is the complaint petition, lordship. Page 23 is
you come to page 17. 17 is the appellate court's order.
apparent.
Appellate. Read page 14, para 14.
On reappreciating the facts as pleaders and deposed in evidence by complaint, it appears that while the accused was facing problem to repay the loan taken from HUDCO and to save the property, namely Kalyan Market, from being sold through auction by HUDCO, they approached the complainant to sell the adjacent property at rupees 6 lakhs. And as they are in urgent need of money, they took rupees 3 lakhs from him by execute one, and by which title deed of property was mortgaged as with complainant as security. On knowing the facts of the said property has already been transferred to somebody else. When the complainant persists state for returning the money. The check was issued to him on deposit. The check was dishonored and returned with the check return memo. And the matter was informed to the accused person and accordingly notice was served. During cross-examination, the complainant admitted that prior to the filing of this case, he represented the accused Bikram Datta in another case as advocate. And for the matter of mortgage, he did not bring any civil suit. The complainant denied the defense suggestion that the check was issued towards his professional fees as advocate, and also denied the check was issued as a security check. During his evidence as DW1, accused Vishal Datta deposed that he issued the check of rupees is
3 lakhs.
and 3 lakhs towards
The
professional
complainant
fees.
is an advocate.
Yes, Lordship, he was an advocate, he died, Lordship, subsequently his wife is substituted.
Yes, when money has been taken.
Lordship, that money has been adjusted, Lordship, may come to page 41, paragraph 31 of the learned CG.
40?
Page 41. Paragraph.
You are
31.
for the complainant.
I am for the, yes, complaint, respondent number 2.
Yes.
Paragraph 31, page 41. I am of the opinion that the imposition of fine only would meet the end of justice. The accused Vishal Datta DW1 in his testimony stated that on 24/1/2013, an amount of rupees 25,000, on 28/1/2013, amount of rupees 5,000, and on 16/3/2013, amount of rupees 25,000 were deposited in the SBI account of the complainant. The Exhibit 8, Exhibit C, and Exhibit D shows that a deposition about the mentioned amount in the SBI account of the complainant. However, it is not clear.
So that is not disputed that you've received the total amount of 1,20,000.
He admitted, and thereafter amount was adjusted, and ultimately conviction was passed for. Because 1,80,000 was remained unpaid.
I don't find any merit. What is material irregularity? What is the error? There are
Here-
evidence, based on evidence. Now, this court cannot go in revision, appreciate these evidence.
And lots of interestingly, after filing of the complaint, he made this amount, paid this amount. So if the ground taken by the petitioner not the same.
This order at page 41 is the order of the
Trial court. Trial court.
trial.
Additional CGM.
It starts from
It starts from page
27.
27 lots.
Yes.
Also, initially the complaint was filed against 2 persons. 2 persons and the deed.
Concurrent finding.
Yes, okay.
I don't see anything. I'll dismiss it.
And
Anything you want to say to change my mind, you're welcome.
And lots of only fine has been imposed, but sentence has not been given, only in the form of fine.
So that is what he's challenging.
Lots.
All right, right. Item number 3. You are Mr.
S.J. Sharma.
Heard Mr. S.J. Sharma, learned counsel for the petitioner. Stop. Also heard Mr. S.C. Kayal, learned counsel appearing for the respondent number 2 stroke complainant. And yes, S.H. Bora and M.S. S.H. Bora, learned APP for the state respondent. You want to say something? The instant criminal revision petition is filed under section 497-401, read with section 482 of the CRPC for suspension of the for setting aside of the conviction and sentence in judgment and order dated 7/12/2018 passed by the Learned Court of Session Judge at Jorhat in connection with the criminal appeal number 8 stroke within bracket 1 of 2017 under section 138 of Negotiable Instrument Act 1881, whereby the appeal by the accused petitioner have been dismissed and the order passed by the learned additional chief judicial magistrate Sibsagar in CR within bracket NI case number 240 of 2010 is upheld, where under the accused person is sentenced to pay a fine of rupees 360, 000 within brackets words only, and in default of payment of fine to undergo simple imprisonment for 1 year. Stop. The facts of the case is that the complainant lodged a complaint on 12/11/2018 alleging inter alia that the petitioner, along with few family members, had constructed a market complex by taking loan, and in the month of November 2007, in view of the financial problems, the petitioner approached the complainant not financial problem, sorry. And that in the month of November 2007, the petitioner approached the complainant stating that the HUDCO HUDCO has been preparing to put the said market on auction for non-payment of loan, and to save the same, he requested the complainant to give him money. Stop. It is further alleged that accordingly the complainant gave rupees 3 lakhs to the petitioner. It is further alleged that the mother of the accused petitioner also took rupees 5 lakhs from the complainant for payment to HUDCO on the same day. It is further alleged that thereafter the petitioner did not return the said amount of rupees 3 lakhs, and subsequently it was discovered that the mortgage property was already transferred to a third party, and hence after much persistence, the accused petitioner agreed to return rupees 3 lakhs to the complainant, and accordingly issued 2 checks, being check number 908960 dated 31/8/2010, which is the other number, check number. Only one number is given here.
Only one check.
Only one check.
Not
We should check, not 2 checks, right? It should check so and so, amounting to rupees 3 lakhs
not it.
to the complainant. Stop. However, upon deposit of the aforesaid check, the same was dishonored with the remark insufficient fund within quotes. Accordingly, a demand notice was issued and the same being not paid, 138 proceedings have been initiated, have been filed before the SDJM as Sipsagar.
Yes.
The trial court, upon holding the trial and finding the was pleased to find the petitioner guilty under section 138 NI Act and accordingly sentenced him thereof. Against the above judgment, an appeal was preferred before the Court of Session Judge Sipsagar, wherein the appellate court was pleased to dismiss the appeal and affirm the said judgment of the trial court. Situated thus, the present criminal revision petition has been filed. Mr. Mohanto, learned Mohanto, Mr. Sharma, learned counsel for the petitioner submits that the order of the appellate court as well as the trial court convicting the petitioner and sentencing him thereof is erroneous inasmuch as the notice issued under section 138 NI Act is defective. Why is it defective?
It should have been 15 days, Lordship, and a mandatory provision has not been followed.
In view of the fact that the same has not been
Issued in a
issued
proper manner.
issued within the mandatory period of 15 days. Correct?
Lordship, the time given in the notice should have been 15 days, Lordship. But it was 7 days, Lordship.
In view of
Particular
the
notice.
fact that the time for repayment given in the said notice was 7 days instead of the mandatory 15 days. Stop. What do you have to say to that?
Lordship, because after filing of the complaint, he made the part payment. So Lordship, this plea has no stand to.
Per contra, Mr. S.C. Kayal, learned counsel appearing for the respondent number 2 complainant submits that since the petitioner after filing the complaint case has already made part payment of the loan
Check him.
of the dishonored check amount, comma, the plea of the petitioner as regards the mandatory time period provided not being provided in the demand notice is of no relevance. Correct?
Lordship, and this plea was not taken before the trial purpose.
He further submits that such plea was also not taken before the trial. Stop. I have heard, perused. Okay. It appears that that the prosecution has it appears that it has clearly come out from the oral as well as documentary evidence that the check in question issued by the petitioner was dishonored due to insufficient fund in his account. it has also, it further appears that the petitioner stroke accused has not denied the said fact that the check was dishonored. Stop. It further appears that during cross-examination, the plea of the accused person appears to be not consistent, inasmuch as at one stage the accused has while cross-examining the complainant, the accused suggested that the check was issued to the complainant in connection to legal fees, whereas in his evidence, he deposed that the check was issued as security measure. It appears that the presumption it appears that the accused respondent has not been able to disprove the presumption as contained under section 118 of the so-and-so Act, Negotiable Instrument Act, so-and-so. Huh? It further appears that the learned trial court, in light of the discussion of evidence on record, has held that the complainant has successfully established that the accused petitioner issued the check in question to the complainant for the discharge of legally enforceable debt and the check was dishonored due to insufficient fund. Before that, you say that it appears that the trial court accordingly framed 3 issues which reads 3 issues for determination, which reads as hereunder, page 29, 1, 2, 3. Then this paragraph that I have said, it appears that the trial court, instead of saying in the light of above discussion of evidence on record, say as regards issue number 1. Has hold, okay, connected. It further appears that as regards issue number 2, it is evident from the materials available on record that the complainant has issued the demand notice to the petitioner on 7/8/2010 and the same was received by the petitioner within 4 days, but did not make the payment within the 7 days of within the 7 days. Stop. In view, accordingly, the said issue was also, accordingly, the issue number 2 was also decided in favor of the complainant. As regards the issue number 3, apt to reproduce paragraph 25, 26, and 27, 28, 29 of the aforesaid judgment. Stop. Quote unquote. In the backdrop of the aforesaid, the following sentence was imposed upon the petitioner, which reads as hereunder, page 41, paragraph 31, quote unquote. It further appears that the appellate court, after reappreciating the facts and evidence, was pleased to dismiss the appeal by upholding the judgment and order of the trial court. Relevant portion of the judgment and order of the appellate court is also reproduced hereunder for any reference. Page 17, paragraph 14, 15, 16, 17, 18, 19. Till 19. Reading of the aforesaid judgments of the trial court as well as the concurrent finding of the appellate court, there appears no illegality or error warranting interference from this court in exercise of revisional jurisdiction. That being so, the criminal revision petition stands dismissed.
Much of it.
I'll resume in 5 minutes.
That is the translated one.
Page
34.
okay, they've given us 3 stenos or 4 stenos today. Nobody else has been given.
34, my lord. FIR at page 34.
Yes, please. Mr. Mohanto, you are in this case.
And then another one. Same.
You want to lead?
All right, he's one of the accused, my lord, that's right, yes. The crossing of the FIR, my lord. Your lordship kindly see, my lord.
You are in item 5.
Item number 5, my lord. Item number 5.
Yes.
The FIR pays, my lord, 22.
Page 22.
Oh, my lord. No, when you start from 22.
Yes.
Yes.
11%, Lord.
Yes, my lord. Informant.
You are for the
I'm for the informant, Lord.
informant.
Your lordship kindly take up page 22. Informant is Lukumoni Gogoi.
Yes.
and Kulai Gogoi,
Yes.
and accused persons Abhijit Sutia, Tornod Dihingia, Hobon Dihingia, Gunin
Who are
Gogoi.
you?
I am, my lord, serial number 6, my lord, Bhola Tamuli.
And Mr. Munir?
For the rest.
He's
For the rest.
He is, my lord.
You are for 6, Bhola Tamul.
Bhola Tamuli, my lord. Now, he's a government employee, my lord. He was a Mondal at that point of time. Now he retired, my lord. The informant respectfully submit that the accused number 1 has purchased a plot of land measuring 1 bika first class Basti land under block 2, Themaji Nagar, covered by DAG number 45, periodic pata number 35, fraudulently means and of conspiracy. The above referred land was mutated in the name of grandfather of the informant, late Bhubaneswar Sutia, father of witness number 1, and late Tonko Bakal, the one and one Anupam Guhai. The accused number 1 and 2 in connivance with the accused number 3 to 7. Aid of the administrative machinery, in the aid of the administrative machinery for perusal of the gain, along with the official, circle officer, deputy registrar, revenue branch of the deputy commissioner office, Hemaji had forged the land document and registered the deed, hereby violated the rules and regulation of the department. Unless there is a help of coordination of the circle officer, deputy registrar, or revenue branch of the deputy commissioner office, Hemaji, it will not have been possible on the part of the accused person commit such scheme. In this regard, is that it is revealed that the RTI that although the father of the witness number 1 died on 23rd October 87, showing the signature of the person expired in Tonko Bhakal alive in the affidavit in 15 July 2014, and unexpected in the incident that they occurred, unless the accused person 3 to 7 would not have been helped, the accused person 1 to it could have been committed such crime. The complainant is maintained that meantime that he came to know that the place of Anupama Guhai, wife of Sri Basanta Guhai, accused number 2, has sold the land to accused number 1 by forging the signature of Anupama Guhai. And land document 2 also that it was shown that there is a resident of Guhai Gam, but there is no person by the name of Anupam Guhai in the village. The complaint came to know that RTI made by the deputy register office of that the deed executed the sale of land by Anupam Guhai has been signed, and see Anupam Guhai, the age 1, 4, 5, and 6 to Anupam Guhai. The complainant is frustrated with the act of forgery or violation of always been.
Complaint prima facie makes a case on the face of it.
My lord, but how are you?
Allegation is there. What at this stage, this court cannot go into inquiry.
What I am submitting, my lord. This is a prior to filing of this. No, I am a Mondal, my lord, because
Maybe, but you see, the allegation is that with the help of the district administration and office.
My lord, administration, my lord, your lordship, what is the main allegation? There is a first signature by the seller by the but person
registered the deed.
Registered deed, my lord, that is not the duty of the Mondal, my lord. No, that is not the duty of the Mondal, my lord. Registered, my lord, circle officer. Mondal is the, my lord. He has to pass.
I am not inclined at this stage.
No, I'll come, my lord.
Because you see, there has to be something apparent to show that the ingredients are not there or no case is made out against your client. Then, of course, another thing.
My lord, but there is no specific allegation. No, what is Mondal?
Well known to all of us, right?
Now, no. What is their main allegation? Main allegation that, my lord, but they have, my lord, forged the signature of so and so.
And registered the deed.
Registered the deed. There in Mondal has nothing to do with the registered deed, my lord. Registration, nothing, my lord.
If there is nothing, then you have nothing to be scared. Now,
no, but my name is there, my lord.
What has happened? Charges have been framed or not framed? There is a stay.
There is a stay. There is a stay in another case, my lord. No, what happened, my lord? Here in this case, my lord, he has filed a complaint. He filed a complaint. Complaint case, my lord. Your lordship kindly see that I have annexed, my lord, complaint lodged by on 7/9/2018, page 13, my lord.
Page
13, my lord. Page 13, my lord.
Yes. This complaint case is filed by whom?
Same person. He filed a complaint, and that complaint case, my lord.
Subsequently, FIR.
No, my lord, what happened in that complaint case? There is a order passed, my lord.
Okay,
Page, complaint, your lordship page 13 is the complaint, my lord.
yes,
Then, my lord, page annexer 2, page 21 is the murder order passed by the court, my lord.
yes.
Complainant is present, the prosecution sanction is not.
1 second, which page?
Page 21, my lord.
21.
One, my lord.
Yes, please.
The complainant is present, the prosecution sanction is not submitted by the complainant. I have gone through the CR. It appears to me the sufficient time was allowed to complainant for the submitting the
Okay, this is
prosecution sanction.
because of lack of
But the
prosecution sanction.
complaint failed to submit the same. They appear that there is no possibility of submission of sanction prosecution so and so that will be so and so and so and so.
Because
that
of
is-
non-submission of prosecution sanction.
That is still going on probably, I don't know. What I am not on that. But after this order, he has filed a police
FIR.
case, my lord.
FIR.
But not a single line. He has stated that, my lord, I have filed a complaint.
Hmm.
I have filed a complaint, my lord, because when they one complaint and police case and my lord, complaint case cannot go together. There is a provision by 210.
But
It has to be,
complaint
my lord,
case
one
is
is to be
already-
state.
Complaint case by then has already been,
Proceeded, my lord.
no.
No, what happened, my lord? The complaint submitted the prosecution sanction. So until and unless he has, my lord, filed a prosecution sanction, that will not be proceed.
So it says it will not be proceed and it will be restored as soon as the complaint
Complaint
submitted
is, my lord.
prosecution
But
sanction.
he, instead of going to that, my lord, he come to this, my lord, file a complaint case, file a FIR before the police station, but not a single line that there's a complaint case pending. So that's why I'm submitting, my lord, with a malified intention to, my lord, just to, my lord, take the, my lord, that person concerned, my lord. At that point of time, I came before this honorable court. At that time, I was on the verge of retirement, my lord. For retirement, if I'm arrested, my lord, I should have, my lord, not get any pension and also, my lord. So in that state, but other accused, my lord, they are representing my learned friend. And my lord, already there is a mutation case also pending among the parties. The person agreed they have no complaint, my lord. But only this, my lord, the person who, my lord, filed lodged in FIR said that my grandfather's signature has been false. So that is the only allegation, my lord. So as
Which
a,
is
my lord,
that decision you are relying?
my lord, is a Malafile Institute.
No. Both complaint and FIR
On
cannot.
that section, my lord, if there is a simultaneously, if there is a complaint case or any police case is going on, then there has to be one application has to be filed, and one has to be stayed. The 210, my lord, CRPC.
But here, admittedly, the complaint case is now not proceeding.
Probably that is here his lapse, my lord.
No, whatever.
No, my lord, I am not on that, my lord. Why manifestly? Well, because he has not a single line. He has
You are
mentioned in
saying that he has not whispered, not disclosed,
my lord.
correct? Yes.
210, my lord. Normally, the complaint is be stayed and a police case will be gone. If, my lord, there are two cases on the same offense, my lord.
Yes, anything else?
So that's my case, my lord. Actually, my lord, my case is so far as I am concerned, Mondal is
Yeah,
concerned, my
all
lord,
right.
he has nothing to do, my lord. Manifestly, my lord, he has been implicated as a party, my lord. That's my case, my lord.
Yes.
My lord have gone through the FIR, my lord. The petitioner number 1,
In your brief, FIR is at which page?
FIR, my lord, at page 33.
No, FIR is not 33.
Oh, I'm sorry, my lord. It's 34.
Yes.
The accused number 1, hearing the petitioner number 1, he purchased a plot of land, my lord. And that was subsequently mutated in his name also, my lord.
But Mr.
That-
Munir, the allegations are serious about forging and selling and then thereafter registration. These allegations now,
Yes.
I'm not convicting you. I'm not going to be looking into the merits of these allegations. I have to assume that these allegations are true.
My lord, if I may-
And assuming they're true, I have to see whether a criminal offense is made out or not.
Fine.
Now, if assuming these allegations are true, a serious criminal offense is made out.
No, my lord, assuming it.
Why should this criminal proceedings be scuttled at this stage? In fact, this is of a 2019 matter.
Fine.
Still, it is stayed. We are in 25 now. Criminal proceeding has not moved an inch because of the stay order that you have got.
Now, my lord, what has happened, my lord? The allegation that has been brought in, the land was, my lord, there was co-partners.
This court cannot go into all that.
Yes, now they have to, the sign, the allegation regarding the forging of the signature, my lord, that has been done.
Maybe whatever you are saying, if these things comes out, maybe the charge may not have been also framed. Maybe you are discharged, but you are not. But that stage has not come because of the stay order.
True, my lord.
Nothing has moved. I'm sorry. It appears to be a complete abuse of court process. Obtained stay on the face of it, the allegation. Can you say that the offense is not made out on the face of the allegation?
Offense is made by someone else. That is what.
Whatever. These are things which has to come out later.
My lord,
The-
kindly appreciate one thing, my lord. They are alleging the forging of the signature in an NOC. That has to be provided by the seller. Here, the
Come
petitioner.
to the contents of the FIR. The accused number 1 and 2, in connivance with accused number 3 to 7, with the aid of administrative machinery for personal gain, along with the officers of so and so, had forged the land document and registered the deed. It's clearly given. In this regard, it is revealed from the RTI that although the father of the witness number 1 died on 23/10/1987, showing the signature of the person expired Tonko Bakal alive on the affidavit on 15/7/2014, a dead man is made to be alive. How
Exactly,
can
my
this
lord. Now,
court ignore all these allegations?
Yes, allegations are on whom, my lord?
Whatever.
This document has been prepared by the seller. Here, the petitioner before lordship is the purchaser. NOC is to be made by the seller. When the land is, there are co-partners in the land, my lord.
Seller is not accused.
No,
You are the person who has purchased.
purchased it.
So, the allegation is that you have forged it.
I cannot force it. NOC even I cannot force.
Allegations are that.
My lord,
Allegations are that
only the
you have
seller,
forged it.
it is the seller who has to bring the NOC,
Sorry.
not the petitioner, not the
Sorry.
purchaser. My lord, you kindly appreciate this fact, my lord, because the land is, there are
The
co-partners, my
trial
lord.
court will look into it, discharge you in that case. Why should this court, correct, charge it, that's what I'm saying. It is at a very crucial stage. Why should this court exercise quashing power in such a matter? If you have not done anything, why are you scared?
No, my lord, then, my lord, let those documents be brought on, my lord, because
Not what documents to be brought on? How can this court go into all this? I'm sorry.
now, my lord will kindly appreciate one fact, my lord. If I may submit, my lord.
Yes, please.
As the land was, there were co-partners, my lord, therefore, to sell a land, my lord, of Azmali, my lord, there has to be NOC from the co-partners. In this NOC, my lord, this Tankal Bahal had signed it, my lord, after that has been projected. Now, this NOC is to be made by the seller, not the purchaser, my lord.
Yeah, Mr.
There is no,
Munir,
no
there's no point of repeating your submissions. There's no point of repeating your submissions. I have noted your submission and I'm rejecting it. I have noted your submission. You want to add something more? Please do.
And regarding the FIR after the complaint, my lord,
But it is ultimately the discretion of this court, right? I am not inclined to
If I may,
watch this FIR.
if I may rely on it,
Yes, please, please.
of my lord, that is Orang Bombay High Court. My lord.
Bombay High Court.
My lord.
What happened to all the apex court decisions
Apex
of
court is
Cushing?
not,
Huh?
regarding the complaint after the FIR, that is could not
I'm
find.
not bound to follow.
Yeah, but that is the
Bombay High
position
Court,
of law, my
huh?
lord. That is the position of law, my lord.
What position of law?
Yes. Well, if there is a complaint, my lord, the two investigation cannot go on.
There is, you see, even that argument, as far as the facts of this case is concerned, admittedly, the complaint case is not proceeding. Be whatever reason. At this stage, the complaint case is not proceeding.
True.
Correct?
True.
Then how can that be there? And which was that section, Mr. Mohanto? 210. Now kindly see, take 210 for a moment. Please have it. Let us test your argument. You may have a point. Let us test it.
The law is that 210, that complaint will be saved.
I have seen it, Mr. Mohanto. I have seen it. That is why I wanted Mr. Munir to read it.
The complaint will be still, but
Please read.
that is not proceeding.
Please read, Mr. Munir.
I got it, man. I know it.
Please read it.
When in a case instituted otherwise than on a police report, it is to
Make
appear to
clear.
the
It
magistrate
is made to appear
to the magistrate during the course of the inquiry or trial
held by
held
him.
by him that an investigation
The
of
case is in
by
progress.
police is in progress.
In relation to
that
the
is-
offense, which is the subject matter of the
Well,
inquiry or trial held by him, the magistrate shall stay the proceedings of such inquiry or trial and call for a report on the matter from the police officer conducting the investigation. If a report is made by the investigating police officer under section 173 and on such report cognizance of any offense is taken by the magistrate against any person who is an accused in the complaint case, the magistrate shall inquire into or try together the complaint case and the case arising out of the police report, as if both the cases were instituted on a police report.
That will be club.
These stages have not come.
No.
That
we are
complaint case is not even
I'm
progressing,
not relying on this, man.
not
What-
relevant for the purpose of this case.
This is not. We're not
Anything
relying.
else?
We're not relying on it, man.
Anything else?
But
Anything else?
Two cannot be investigation.
You're repeating it now. I have heard it. Anything else? So your first argument is that reading the allegations, no cases made out against you. Number one, right? Second is that both the cases cannot go simultaneously. To that, you wanted to rely on some decision of the Bombay High Court. Give it, give it.
Paragraph 19, man. I've just read it right.
Yes, highlight it and give it. Anything else?
This is out and out at civil dispute, man.
All right.
Try to give an
All right.
criminal color, man.
All right. Anything else? Para 19.
Para 19, man.
The object is that for the same offense, there should not be a separate investigation,
Right.
two separate investigations. If it is of one offense, and if there are two cases, it can be done at one.
Yes.
That is the basic object. Now here one has already been not progressed because of lack of section. Okay.
And
Yes.
these sections for regarding cheating, there has to be some inducement on the part of the accused. But here, the NOC has been signed.
You see,
There is no from
it is
the-
at a very initial stage.
but
I am
the
not on
FIs
cheating or anything.
My lord.
The allegation makes out a criminal case. I am not repeating myself again. Now at the stage of, there is a stage where the charge sheet has to be filed. That has not been done. We don't even know at this stage whether charge sheet will be filed ultimately or not. Under what provision the charge sheet will be filed. We don't know, right? And now even after assuming the charge sheet is filed under some of these sections, tomorrow what will happen before the trial court also we don't know.
My lord, can I make it
So at
can I
this
make the
stage,
prayer
it
in
is
this way, my lord?
too early. It is too early in
Can
the
I-
day.
Can I make it?
And so many years have already gone by. I can impose cost.
That was an order given by the court, my lord. Now the cases
I
are not
can
being
impose
listed.
cost. I am of the view that there is an abuse of the court process by obtaining stay for so many years. Where is the stay order?
Stay order, my lord, 19/8/2019.
So many years have gone by.
Cases are not being listed, my lord. My lord, you can see the.
You have also not made any effort to get it listed. Why will you? You are enjoying a stay order, Mr. Munir.
This
No,
is-
no, my lord, they are also taking time to file affidavit, my lord, that is, there is one complaint.
All right, I will not take it to that extent. But I'm indicating I'm not happy with the way these criminal proceedings have been not been allowed to proceed. If there is nothing is going to come out. Anyway, take it. Duta cases a day.
My lord, may I make it? small-
Yes.
Small. The charge sheet will be filed on the basis of the one.
Sorry.
Charge sheet
Hmm.
will be filed on the basis of the 161 statements. Those should be in the case diary. Since there is an order, my lord, back on 2020 to produce the scan copy of the case diary, my lord, that is not before your lordship. If the statements would be before my lord, then the situation can be different.
Which order?
My lord, 11/3/2020.
In your case?
Yes, 944. 11/3/2020.
2020.
2020. There was an order for production of the scan copy of the case diary.
I can't find that order.
Or my lord, can it be, it may be, my lord, 31/3/2020.
No.
31/3/2020.
No. Okay. 8/11/24.
I'm sorry, my lord.
Yes. Mr. Sharma,
My lord,
you have it? When
No.
will you have it?
my lord, today not received.
Wednesday?
My lord, I will try, my lord.
Because I've already heard this
My
matter.
lord, my lord,
Wednesday.
my lord.
I'm taking the arguments to be completed.
My lord,
There will, we also.
Of course, we will
161
now see whatever is
My-
there.
my lord, from the FIR, it's a prima facie is there. my lord.
Heard Mr. T.J. Mohanto, learned senior counsel, assisted by Mr. D. Mohanto in criminal petition 1461 of 2019. Correct? And Mr.
PK Munir.
P.K. Munir, learned counsel, appearing for the petitioner in criminal petition number 944 of 2019. Stop. Also heard Mr. B.K. Gogoi, learned counsel, appearing for respondent number 2 and 3, and Mr. P. Sharma,
My lord,
learned additional APP for the state respondent. Stop. Upon completion of the arguments made by the learned senior counsel and learned counsel for the petitioners in both the criminal petition, it has come to the notice of this court that by order dated 8/11/2024, the scanned copy of the case records
Right.
has been called for from the court of the trial, from the court of
My lord, FIR, my lord.
FIR from IO, my lord.
scanned copy of the case diary, sorry.
Case
My lord,
Case
is it-
diary has been had been directed to be placed before this court on the next date of
My
listing.
lord.
Stop. Today, when the matter has been taken up for hearing at the admission stage, comma, however, the said scanned copy of the case diary is not available with Mr. P. Sharma,
Right.
Lanet APP for the state respondent. That being so, let the scanned copy of the case diary be placed before this court on the next on the next date of listing, i.e. relist on Wednesday date to Diok. Wednesday or Friday?
Thursday, my lord.
Thursday,
Thursday.
Thursday. Huh?
Okay.
Relist on
Take a moment.
so for further hearing.
Mother, in the morning, I made a prayer for little accommodation. In fact, my lord, in this petition, we are challenging the order.
All right, you wanted some accommodation?
Yes, my lord.
Mr. A. Dhar, learned counsel appearing on behalf of the petitioner, seeks accommodation in the matter on the ground that Mr. A. M. Bora, learned senior counsel leading the brief, has some personal difficulty today. Stop. Prayer is not opposed. Relist
Look, next week, my lord.
next week or date did you relist on such and such date?
26th. So 7 is also arising out of same order.
I am not saying anything. I'm giving a common order, 6 and 7 corridor.
Obliged, man. Interim order may be continued.
Interim order, if any, shall continue till the next date of listing.
26th.
It is needless to be clarified that since the matter pertains to the year 2019, no further adjournment at the admission stage shall be granted to the petitioners.
In fact, my lord, the informant was not been served, would not be served here in this matter. Because it's a case of suicide, abatement of suicide. And we have taken steps.
Let's call next.
Obliged.
Please, Lordship.
Yes.
Lordship, as per the earlier order, Lordship, LCR was supposed to come, Lordship. And Lordship, I have to.
What was supposed to come?
LCR, Lordship.
I see
not
the trial
come.
court records.
It has not come, Lordship. And Lordship, I have to also file a petition before the court below, Lordship. That also, Lordship, I have to file on the Lordship.
Reminder for TCR. Relist after 2 weeks, 3 weeks on a date to be fixed by the registry.
Lovely.
Yes.
9.
TCR আহিছে নেকি? আহিছে. None appears for
None.
the. You are there in item 9?
No.
None appears for the appellant on call. Heard Mr. P. Sharma, learned APP for the state respondent. What happened to the? This is an offense under.
Item number 9.
You are appearing.
Lordship.
None to kata hai. Kar naam to detail. Your name?
IU Chaudhary, Lordship.
Huh?
IU Chaudhary. On
I.U. Chaudhary.
Lordship.
Yes. What about service on R2?
As per number 2 service regarding service. Lordship, I have not gone through the office note, Lordship.
Why? You are not aware that the matter is listed today before this
Lordship.
court?
Lordship, may-
What prevented you from going through the court records and find out why the matter is listed?
Lordship may take up after some time, Lordship. In the meantime.
This is not how the court proceeds, Mr. Counsel. This is not some trial court. This is a constitutional court.
Lordship.
This is not how one is expected to.
I'm sorry, Lordship.
You don't have to be sorry, but you see,
I was under impression that my colleague is there, Lordship.
All
That's why,
right.
Lordship. Some
you have a look.
Lordship. Deeply apologetic. Service awaited, Lordship. I maybe take fresh steps, Lordship.
Mr. So-and-so, Learned Counsel, seeks accommodation in order to take fresh steps upon respondent number 2. Prayer is allowed, relist after 2 weeks on a date to be fixed by the registry. It is observed that the TCR call for has been received.
Deeply obliged.
Please, your lordship. A matter may be taken in another day.
Huh?
Matter may be adjourned for the day, lordship.
I'll do it.
Service company হলো?
2016 service report it is awaited বলে দেখাইছে। And-
TCR আইছে নাকি?
Step লইলো না দিবে এখন তো সিনেমা মানে
Yes, I've seen it going next level.
Yes, what about service?
Service, respondent number 2 is service awaited as per office in 2016.
Then why are you seeking time? Why are you not saying? See, when matters are listed for orders, it is listed for some specific purpose.
Lordship.
Simply coming and seeking adjournment of order matters is absolutely not appreciated by this court. The office spends a lot of time and energy in getting these matters listed. If the service report is still awaited, it's a 2016 matter. What is to be done then? You must take some initiation. Are you going to take fresh steps? What is this appeal under? Section is NDPS.
NDPS, lordship.
Then it has to be served. Who is the respondent number 2? Complainant.
In charge of Tarapur TOP, lordship.
Mr. Sharma?
My lord, perhaps we can take receive them, my lord.
You can receive.
Name was, my lord, that's why. As per name, my lord, name was mentioned.
You take it.
My lord. My lord.
It appears from the office note dated 28 of the last office note dated 28/9/16 that service in respect of respondent number 2 is still awaited. It appears that respondent number 2 is SI in charge of Tarapur TOP, PO and PS Silchar, District Kachar, Assam. Who is he? He is the
Perhaps informant.
stroke informant. Mr. P. Sharma, learned APP for the state respondent, accepts notice on behalf of R2 and as such service in respect of R2 stands complete. I said TCR. It further appears that the TCR has been received in the meantime.
Say, I said.
Let the case be posted for hearing.
Hearing, my lord.
List after 4 weeks.
My lord.
List.
Or usual course.
What usual course? The 16 matter. Accordingly, list for hearing for hearing on any date to be fixed by the registry in the month of May 2025.
My lord.
Much over.
কিমান বছৰ conviction? Conviction কিমান বছৰ?
Item 25.
Item clear. Clear.
Yes.
May please, your lordship. There has been an oversight on the part of the appellants, your lordship, in filing the paper book. Your lordship will grant us a week's time. There's a stay operating in our favor, your lordship. There's a stay operating in our favor. Your lordship will grant us 1 week's time. Let the matter be listed as per your lordship's convenience.
From 2017.
Yes, yes.
Sir, may kindly peruse the office note that 10/3, my lord. 10/3, my lord.
Paper book, no?
Yes.
Will be
Last chance is given to you.
the last chance. Yes. There's been no oversight.
Mr.
M. Sharma. Your
M. Sharma, learned counsel for the appellant, seeks further
week's time.
week time to prepare the paper book,
Yes.
as granted, to prepare the paper book on paper book. Stop prayer is allowed. Relist after a week on a date to be fixed by the registrar.
I'm grateful, Your Lordship. There's no oversight.
None at that, madam. This is the appeal against equity here.
অলপ পিছত কোনোবা আহি যাব পাৰে।
Right. Lordship, may kindly peruse the office note dated 22/2025. Lordship, I am for 15, Lordship.
You are in
this
15.
15.
আহিছে নেকি trial court records?
Lordship, record is
record
received, Lordship.
And what about R2 service still awaited?
My
No,
lord.
Lordship, as per office note dated 20, Lordship.
No, in your case.
Lordship.
আৰু এটা আছে না?
Item 15, Lordship.
22.
In 14, who is appearing for the appellant? You are not appearing in
No,
14.
no, Lordship, I am for 15, Lordship. 14, Mr. D. Shakia.
20, my lord. 2/02/2025. Office note. Madam.
Lordship, here in this case, Lordship, as per my instruction, Lordship, the appellant
No,
died.
here also it says steps has not been taken.
Steps has not taken, Lordship.
Then
Lordship, as per instruction, Lordship, the appellant here in this case, Lordship, he died, Lordship. So Lordship may, report may be called for from the concerned office, Lordship. OC, Lordship.
appellant,
Lordship.
you are the appellant.
Lordship, I am for the appellant. Lordship.
Then you inform.
My lord.
Why should we call for a record,
You produce
for a report?
he will have to produce the document
Okay.
that he is dead. My
Lordship, may
lord.
fix a date.
Are you not being in touch with your, with anyone?
No, Lordship. Because the whole pending case, Lord, 2017 Lordship case.
How can you get that information, Mr. Sharma, from the jurisdiction?
My lord, that may be done.
It is submitted
from
in item
Lordship.
number you write this in
Yes,
item,
case number
in item
11.
14, none appears for the appellant on call. It appears that service in respect of R2 is still awaited.
My lord.
In the connected criminal appeal, criminal appeal 149 of 2017, Mr. So and so, yes, your name?
Ayu Chaudhary.
Ayu Chaudhary, learned counsel for the appellant, submits that perhaps the appellant in the meantime has expired. Stop. Mr. P. Sharma, learned
B.
APP,
Sharma.
B. Sharma, learned APP for the state respondent, seeks 2 weeks' time to call for a report from the jurisdictional police
My lord,
station.
officer in charge of the matter.
Bilashipara PS, Lord. He is under Bilashipara PS, Lord.
Jurisdictional
case-
police
My
station,
lord, my lord.
Bilashipara, Lord.
I. Bilasipara,
PS case number to koi diya?
No, Lordship, Tengakhat mane. PC to Rosina. PS case, Lordship, Tengakhat,
you
PS case.
put it in that notice.
My lord.
The jurisdictional police station, as regards the status of the appellant
My lord.
in criminal appeal number
Can you
149 of 2007.
My lord.
Relist after 2 weeks on a date to be fixed by the registry.
My lord. A petition to move. As we have no petition, my lord, it's all well.
Please give him,
My lord. I have
please,
asked.
give him the
My lord,
assistance.
I'll take from him.
POCSO,
My lord, notice, Lordship may kindly peruse office note 29/8, my lord. Office note 29/8/2024, my lord. Our flag mark is there, my lord.
no, it's not there. The 16/3/25.
My lord, sorry, my lord.
16.3.
16/3.
It appears that the trial court records, it appears from the office note dated 11/3/2025 that a letter has been received by the registry of this court
My lord.
from the district and session judge
Kuntu?
Sunitpur Tejpur, stating that the
Yes, go ahead.
original case records of sessions case number 336 of 2012 has already been transmitted to this court in connection with Criminal Appeal 460 of 2019. Relist along with Criminal Appeal 460 of 2019.
I'm for a private respondent.
After 2 weeks on a date to next week on a date to be fixed by the registry. Number didiba.
Follow.
I'm just reading out the operating part. In the aforesaid backdrop of facts and circumstances of the case, it is apparent that in view of the high impurities present in the two chemicals in question, the central government has proposed to make BIS standards mandatory in respect to the said two chemicals, amongst others. And after following the procedure mandated in the BIS rules, the draft notifications have been published. It is further apparent that all stakeholders have been consulted by giving due opportunity of hearing, and after consideration of their grievances, etc., the notification for making BIS marking mandatory in respect of the two chemicals has been notified. The purpose of setting higher standards on the two subject raw materials is to protect the human health and overall ecosystem. Thus, I am of the considered opinion that the impugned recommendation and directions thereof for use of standard mark in relation to the two raw materials in question is made in the larger public interest. That being so, this court cannot interfere with the soundness and wisdom of a policy taken by the expert body of the government in the larger public interest merely because it does not suit some section of the public. That apart, this court cannot decide on technical and scientific issues under Article 226 and 227 of the Constitution of India. Accordingly, this court finds no illegality, irrationality, or arbitrariness in the decision-making process for making BIS standard mandatory in relation to the two raw materials in question, and hence the writ petition is devoid of any merit whatsoever. Resultantly, the writ petition stands dismissed. Interim order, if any, passed earlier, stands vacated. No.
I'm sure will land be a benchmark, Malads. And these are the only two chemicals, Malad, may I say this, which are not under BIS. The rest, all other chemicals are under BIS. I'm so grateful.
I'm sorry there has been some delay.
No,
in,
Malad, absolutely fine. We completely understand the pressure.
Pressure is one thing, but when the compilations, voluminous compilations are
we actually
submitted
complicated the whole
the written arguments, as by way of written arguments, it actually complicates, you see.
Correct.
So then
And
that delays the whole process.
And I can see a Lordship has given a very comprehensive judgment, Malad. I'm so grateful.
Sorry. Number 20. Yes, Mr. Sahaiwala.
This is conviction under section 354, my lord.
Conviction under
354.
354.
354. My lord, the lordship find, my lord, from the trial court judgment, my lord, that these many things, my lord, which are not said before the police, they have used it here. My lord, here the conviction is for.
But you are trying to, one of your ground is that the witnesses.
Yes, my lord.
Has stated
the main witnesses
things which were not said in their 161. But is there any inconsistency?
Yes, too much, my lord. And moreover,
during cross, have you brought out these inconsistencies?
Yes. These are brought out, and moreover, my lord, section 360 has not been, my lord, invoked in this matter. My lord, this is the offense, my lord. 360 should have been done, my lord. They must discuss why 360 should not be given, my lord. There's several judgments of the Supreme Court also. Under 360, my lord, the person may be released on admonition or other things here because 6 months imprisonment is there, my lord, in this case. If your losses comes, my lord, I'm just.
Any private respondents? No. Yes.
A few things, my lord.
Page 13.
No, first, my lord.
You are challenging the trial court order.
Trial court, as well as the
appellate.
court, session court has not discussed so much, my lord.
Both trial court and appellate court.
Yes,
I think we can
My
go to
lord,
the judgment.
just your lordships may come to page 21.
Yes.
Second paragraph, PW Sunamoni Singh.
Yes.
Sunamoni Singh did not tell that his wife expired about a year back and his brother's Roman's daughter came to his house and cooked for him. He
Mrs.
did not-
Ayala, let us start from the beginning, otherwise I shall not be
Yes,
able
correct,
to
correct, ma'am.
understand anything.
Correct.
Yes. Let's come
Well,
to
page 13, my lord.
page 13. Yes. FIR is,
Yes.
yes.
My lord, even without going to this, my lord, if your losses can exercise 360 also, I say, my lord, I can place, my lord, the my lord.
No, all right, but
Yes.
see, I have to author a
Yes.
judgment, Mr.
My lord.
Sahaiwala.
My lord, page 13. The brief story of the prosecution case is that on 4/4/2005, at about 8:30 p.m., while the elder brother's daughter of the complainant, Srimati Anita Devi, was going to her house from the house of the complainant at the time after crossing about distance of 50 meters from the house of the complainant, the accused most illegally wrongfully restrained her on the way, showing dagger, and started misbehaving with her and outraged her modesty and attempted to commit rape on her. At that time, the helpless victim raised a cry to save her. Hearing her cry, complainant and Sri Jugal Singh, Rina Devi, Rajmani Devi and others rushed to the place of occurrence and found the accused trying to gag her mouth and lying on the ground. And on being seen them, the accused hurriedly left the place by leaving her laying on the path. The opposite persons have seen and could not identify a person. Thereafter, the victim Anita Devi was brought in the house of the complainant, and victim narrated the incident there. To that effect, the complainant filed a complaint case in the court of the Lioness CJM Kachar with a prayer for sending the complaint to the OC Lakhipur for police investigation. My lord, here what happened, my lord? He did not go to the police, my lord. He filed a complaint. Next day, the complaint was endorsed by the judicial magistrate for the police and handed over to the complainant. Complainant, my lord, delivered to the police after 3 days, 4 days. Accordingly, the complainant was forwarded to OCPS with a direction to register a case. The officer in charge of Lakhipur police station and received a complaint, registered a case and endorsed for investigation. After completion of the investigation, police submitted charge sheet on 342, 354 IPC against accused person and thus laid down the charge sheet under the aforesaid sections law. Copies of documents shown.
All right, come to page 15.
Page
15 PW1.
Yes. Sanamani Singh deposed that he is the complainant. The incident took place on 4/4/2005 at about 8:30 p.m. At the time of incident, he was available at his residence. About 1 year ago of the incident, his wife expired, and thus the daughter of the elder brother, Rahman Babu Singh, namely Anita Devi, used to cook for him in his house. On the night the incident took place, he same came to the house for cooking. He said nephew at about 8:30 p.m. was going to her home after cooking. Her residence is about 100 meters away from her house, his house. After some time of the departure of his nephew, he heard shouting of his nephew. On being heard of shouting, he rushed towards the source of shouting. His neighbor Jugal Singh, Rajmani Singh and Rina Devi also went there after hearing the shouting. On reaching at the place of occurrence, he saw the accused wife Pradeep Singh was running away from the place of occurrence. Anita Devi was lying on the road at the place of occurrence and crying. Then he and about the above named persons present in the place of occurrence took Anita Devi to her residence and inquired about the incident and came to know that while she was going to home on her way at the place of occurrence, the accused restrained her by and caught hold of her hand, pulled her, and by showing knife, threatened her not to raise alarm, and accused put her hand on her breast and other parts of the body, and thereby outraged her modesty. And while the accused tried to lay her on the road forcibly, she started shouting. He inquired Anita Devi about any love affairs with the accused, to which she replied that she had no such affairs with the accused. On the next day, he filed a case in the court. He did not approach the police station at first out of fear. Case was forwarded to police station from the court. During investigation, police recorded his statement so and so. During cross-examination, he said that no village headman in their village, but there is GP president so and so so and so. On the way from his house to the court, there is a Rangpur outpost. There is no residence in between his house and that of his nephew. But so far south, there are some houses. He denied that he did not tell police 1 year ago when the incident his wife expired. And for expiry of his wife, his daughter.
All right, we can, I think, come to Anita Devi now, page 17.
Yes. Yeah, page 17. Anita Devi deposed the complainant is the uncle on 4/4/2005 Monday at about 8 p.m. She was going to her house after preparing food in the house of her uncle Sonamani Singh. While crossed the distance of 50 meters from her house, uncle on the road, all on a sudden, accused wife potentially restrained her from showing a knife and threatened with her dire consequences if she raises alarm. Accused put his hand on the breast and also laid her on the ground. Then she started shouting. Then the complainant Sonamani Singh, Jugal Singh, Rina Devi reached the PO. On seeing them, the accused released her and fled away. Her uncle also and those named persons took her in the residence, and she reported about the incident to her uncle and those people. She known the accused well, Pradeep Singh, being a native villager. His residence is about 100 meters away from the house of the complainant. House of Jugal Singh is adjacent to the house of the complainant. She had no love affairs with accused Pradeep Singh. Complainant so-and-so. Police got medically treated and recorded the statement. During examination, she denied that he did not tell police. The accused at the first, showing her knife, restrained and threatened her with dire consequences if alarm is raised, and by pulling her laid on the ground and complained others, brought her into the house, and she threatened narrated this incident to him. Well, this is the thing, my lord. She did not tell police, my lord. This is my lord. 342 has been, my lord, accused. She also denied that he told police that the distance to the house and her uncle that of 300 meters. She denied that while going to her house after cooking
How
food.
is it material even if she has not said all this?
Yes. My lord,
The material particulars she has said.
my lord,
The factum
my
of
lord, why this had happened, my lord, that the defense has said that, my lord, that because there was some enmity, my lord, there was a proposal for marriage, and the accused has refused, my lord. That is why that has been done, my lord. That is that, my lord. Because even when an informant, my lord, he did not.
The courts, the trial court and the appellate court have evaluated the evidence, analyzed it, and has given a verdict.
Yes.
Now, this court in the revisional, while exercising revisional jurisdiction,
Yes.
as you know, is going to, it has a limited
My lord,
jurisdiction. This court cannot now reappreciate the evidence
something
unless and
that,
until,
yeah,
until and
that,
unless something which is palpable or a manifest error.
my lord, here what happened, my lord? On 5th, my lord, 5th next day, complaint was filed. On that day, the complaint was handed over to the informant to hand over to police.
But that is not
My
a
lord, he delivered it
palpable
to
error.
9th, my lord. Well, that is why, my lord, I'm on 9th after 4 days.
There is a delay.
My lord, why, my lord? He had filed a complaint that was endorsed, my lord. And secondly, my lord, that
This was argued before the court,
My lord,
trial court.
my lord,
This point was
not
argued.
exactly, my lord. And moreover, well, that you have,
Was it argued
Huh?
before the appellate court, this point of
my
delay?
lord, it's, from the judgment, it does not see, my lord, that points were there. My lord, moreover, I have, that is why I have argued, my lord, that 360 is important, my lord.
What
360,
is 360?
my lord, yes.
Yes, 360.
When any person not under the age of 21 years of age is convicted of an offense punishable with fine or imprisonment for a time of 7 years or less, or when any
360.
person,
Mr. Sahibara, 360 IPC.
no, 360 CRPC, my lord. No benefit has been, my lord, granted to him, my lord. No consideration also, which is mandatory, my lord.
360. Yes, what do you
Well,
want?
order to release on probation of good conduct or after admonition.
360.
When any person not under under 21 years of age is convicted of an offense punishable with fine only or imprisonment for a term of 7 years, well, this is applicable to him, or where
You
any
want
person
to be released on probation.
probation, my lord, this is
Where is the report that you are on good conduct?
my lord, no, well, first thing, my lord, it's a mandatory consider it, my lord. If you also see, my lord, I have several judgments of Supreme Court also, my lord.
So how this court, revisional court is going to look into this?
My lord, yes, my lord, this court, my lord, can consider it, my lord. This court, my lord, even Supreme Court has considered it, my lord.
It says if it appears to the court, that's why I'm saying where are the where is the report?
My lord, that my lord, mandatory, if you also see, my lord, this
What is
judgment, my lord,
mandatory?
2009, my lord, the mandatory, my lord, for the court, my lord, first before sentencing him, my lord.
That is the before sentencing. Now you are before the revisional court.
My lord, yes, my lord, because that power has not been exercised. So this honorable court can exercise in the revisional power. If your losses, my lord, that revisional, I can bring that also, my lord, the revisional court has exercised this power. Even Supreme Court has exercised such power.
Maybe in a given circumstances.
My lord?
In a given circumstances, maybe. But where are those circumstances in your case?
No, my lord, first thing, my lord, this is a compulsory, they have to exercise, my lord, power. They may reject it.
No, which paragraph, which clause under from 360 you are trying to say that the sanctioning court has to first consider it?
My lord, this, my lord, if you also see the judgment, my lord, the Supreme Court has done it.
Before judgment, you please place
Yes.
360.
My lord, who is convicted, regard to her age, character or antecedent of the offender,
One
the
second,
circumstance
let's go
which
slow.
committed. The
Let's go.
expedient of the offender should be released on
Mr.
probation.
Sahib, let us go slow.
Yes.
When any person
Yes.
is convicted
Yes. Of an offense punishable with fine or
no previous
imprisonment for a term
conviction
of
is
7
true.
years or
if
less.
it appears to the court below, a court before which is he is convicted, regard being had to the age, character, antecedents, and to circumstances in which the offense was committed, that it is expedient that the offender should be released on probation instead of sentencing him at once to any punishment, direct that he be released on his entering into a bond with or and then okay, subclause 4, while exercising its powers of
Yes.
revision.
Yes.
No, but that is why I'm saying now, suppose the court has to exercise this power.
Yes.
Then first of all, the prerequisites.
Yes, my lord.
That if it appears to the court before which he is convicted, regard being had to the age, character, or antecedents of the offender, it has to, everything has to be considered, correct? Now, there has to be some report. Without the report, how will this court exercise its mind?
Your losses can direct the trial court then, my lord, to do it, my lord. Because, and moreover, my lord, This is a incident of my lord 2005, my lord.
So
20
according
years.
to you, it is mandatory
Mandatory, my
on
lord.
the court to record in its judgment specific reasons for
Yes.
not granting benefit of 360.
Yes,
This is not done.
this is not done, my lord.
Yes. What do you have to say to this?
Lordship. Because
Our High
we do
Court
not
judgment
have
is
any
also there,
record to that extent, Lordship.
Which is the High Court judgment?
Yes, I know.
Yes, Ms. Bora?
Lordship, since we do not have any materials, we do not have any reports to that regard regarding the antecedents and good conduct of the
Can it be
appellant.
remanded back to the appellate court
Which a
to
direction
exercise the power under 360?
in accordance with law.
They can reject it by giving specific reasons.
Yes, Lordship, that can be
Hmm?
at the most.
My lord, just your lordship.
Copy from.
Huh?
Copy from.
Copy. But yes. It is perfect. Don't bother. What is selling away from it? Well, this is a case in revision, my district power.
Yes, I've seen.
Power has been exercised.
But you see, for this court, I would have otherwise looked into it, but for that, there has to be some materials.
My lord.
That materials is not available before this court
Yes.
unless and until that
Right.
materials is made available.
Yes.
Now, instead of calling for those materials, I think I can dispose it off with a direction to the appellate court
Yes, Lordship.
to call for a report. And
And moreover, my lord, the 20 years has already lapsed, my lord. For instance.
but if we don't do that, then can this court can call a report from the
Yes.
That can be also done, Lordship.
try that then?
Yes.
Yes.
That can be also done because sending back and all will take time.
Yes,
Yes.
otherwise.
Heard Mr. Sorry, Matiduk.
So Lordship, one more thing, whether this mandatory part of the.
No, that
provisions is-
appears there is a
Whether
decision.
it has the applicability in case of revisional power. High Court, Lordship.
Yes, it is the Guwahati High Court have said, and the section
Subsection
itself
4.
says subsection 4
Subsequent power.
Lordship.
that
Then
High
Lordship-
Court in exercise of revision.
Lordship, then Lordship
So-
may call for a report.
This court undoubtedly has this power.
I could just that's got to get notice of the. Sorry, we don't have to-
How much? Wait. What was the sentence?
Lordship,
6
6
months.
months.
So that must have been already over.
My lord, oh, he was on bail, my lord.
He's on bail.
And moreover, 20 years has elapsed, my lord, for the incident.
That's okay, but
6 months with a fine of rupees 5,000.
heard Mr. G.N. Sahewala, Leonard Senior Counsel, assisted by MS
TJ Sahewala.
T.J. Sahewala. Stop. Also heard MS S.H. Bora, Leonard APP for the state respondent. Stop. By relying on the decision of the apex court in the case of Chandreshwar Sharma versus State of Bihar, reported in 2009 SSC 345, comma, Harivali Abha and another versus State of MP, reported in 2005 10 SSC 30, comma, and the decision of the coordinate bench of this court in the case of Munindra so-and-so versus State of Assam, reported in 2005 3 GLR 618, comma, submits that it is submits that it is mandatory duty, submits that a mandatory duty is cast on the court to record in his judgment specific reasons for not granting benefit of section 360 to an accused where it could have dealt with the accused thereunder. It is submitted at the bar that in the instant case, both the trial court as well as the appellate court has not discharged the said duty as vested under them, as vested upon them under the provision of section 360 CRPC. Correct?
Yes.
Stop. It appears that that being so, before proceeding further in the matter, it further appears that under subsection 4 of section 360, an order to release on probation of good conduct or after admonition can be made by the High Court when exercising its power or powers of revision as well. That being so, before proceeding further in the matter, in the interest of justice, I am of the considered view that a report as regards the age, character, or antecedent of the petitioner, along with the other circumstances as required for consideration of passing necessary orders under section 360 be called for from the jurisdictional jail or police station.
Judicial magistrate, I think judicial magistrate will be better.
From the court of
JMFC Silchar.
JMFC Silchar.
First class.
First class. Stop. Let ordered accordingly. Let registry do the needful in this regard forthwith. I think that should be sufficient.
Yes.
Relist after 4 weeks on a date to be fixed by the registry.
My lord, a copy of the judgment, my lord, it will be sent, I think.
The registry will do it. I said do the needful.
Yes. Okay.
You can take this back.
Yes.
Yes.
My lord, before my lord, start, my lord, I am appearing for the, my lord, Special Public Prosecutor Wildlife, my lord. Just, my lord, I have engaged, my lord, and my lord, I am going through the record, my lord, not completed. But kindly, my lord, accommodate for a.
You have been newly engaged.
No, my lord, actually, it was not informed me, my lord.
Oh.
Today only, my lord.
All right, when?
Well, next week, my lord.
Mr.
I will.
Mr.
B.
P. Sharma. Mr. P. Sharma, Leonard APP.
Special PP Wildlife.
Leonard Special, Leonard appointed Special Public Prosecutor for wildlife submits that he may be permitted he may be accommodated for going through the paper book. Is there a paper book
LCR,
for going through the trial court records, as the same has been made available to him this morning itself, right? Prayer is not opposed. Relist next week on a date. And a date did you next week? Released on such and such date.
My lord.
Date to decide. Date that you.
Date to 27 March.
27 March.
27.
Please, your lordship. Lordship, if permits, I couldn't prepare properly. Probably permits. Can it be fixed on Thursday, lordship?
All right. As prayed for by MS.
M. Nirula, lordship.
M. Nirula, Leonard Counsel appearing for the petitioner, which is not opposed by the other side, relist on Wednesday date to deliver on such and such date.
Obliged, lordship. Obliged.
But in this case, I'm led by Senior Counsel Mr. A.M. Bora. Today, he has some
Yes,
personal
couple of his matters have been adjourned because of some personal difficulty.
He will not be available on 19th also, my lord.
All right, you tell me when you want it. Mr. Kalita.
My lord.
N.
N.K. Kalita.
N.K. Kalita. Mr. N.K. Kalita, Learned Counsel for the petitioner submits that the leading counsel, Mr. A.M. Bora, Learned Senior Counsel, is having personal difficulty today, for which he has not been able to attend the court, and accordingly seeks accommodation for the day. Prayer is not opposed. Relist on such and such date.
After 24, my lord.
24th or pisar the date diyo.
Interim is there, my lord. Definitely.
Interim, if any, shall continue till the next date of listing.
Item 26.
Yes.
Lordship, my petition under section 311 was rejected. I am the father of a girl. She was kidnapped by the OP number 2. And charge was framed under section 366. And on the date of my examination, that date of birth, certificate of date of birth was not available with me. Subsequently, I obtained the birth certificate from the school where I was, the victim was admitted at the first. Then from the admit card, it appears that on the day of alleged occurrence, she was a minor. Now I filed a petition for re-examination so that I can produce the certificate, because at the time of investigation, that particular document was not sealed. That was a negligence on the part of the IO. Now I filed a petition. Lordship will,
the order?
Lordship will find the petition at page 19 is the petition which was rejected.
Mr. Nawaz, you are appearing for?
He was appointed as amicus.
Amicus for the respondent.
Because in spite of service, OP2 did not appear.
Yes, page?
Page 19 is the petition filed by the father.
Yes. Father of the
victim, alleged victim. Subsequently, she committed suicide because of the stigma. She was kidnapped. Subsequently, after 6 months, she committed suicide.
You are appearing, you are for the father.
Father, the victim's
This application was rejected.
rejected. Order will, your
Where
lordship
is
will,
the order?
lordship will find at page 22. Basically,
Yes, please read.
accused Deepak Das is absent with steps by petition number so and so, has engaged counsel praying for
Read
another
from
date.
para 1.
Lordship,
Today
today speaks
is-
for passing order on the petition filed by the petitioner, Mohammed so and so, praying for examination of the headmaster of so and so school, Guwahati, as court witness, stating that petitioner was examined as PW1. In this case, and at the time of his evidence, he could not inform the court the actual date of birth of the victim girl, as no certificate showing the date of birth of the victim was available with him. And thereafter, he applied for a school certificate, and accordingly, headmaster of the said school issued a certificate on 22/3/2018, showing the date of birth of the victim. Hence, prayed for calling of the said headmaster as court witness to prove the age of the victim and to establish that she was minor at the time of the incident. A certificate issued by the headmaster of Sonitpur Lower Primary School has been filed along with the said petition. Peruse the petition as well as the certificate so filed. The petition has not been supported by an affidavit. Heard learned counsel for the both sides. Learned counsel for the accused person has verbally raised objection against the above noted petition, submitting that prosecution has filed the said petition only to fill up the lacuna, and the prayer of the prosecution is not at all genuine one. It is contended that the time of examination in chief of the informant, who is the father of the victim girl, as PW1, has stated clearly before the court as to the birth year of the victim girl, and by filing the instant petition at this related state of the informant has tried to fill up the lacuna, as the birth year disclosed by him during his evidence is not the same as shown in the certificate obtained much later, and there is every possibility that same is manipulated one obtained for filling up the lacuna in the prosecution case. Hence, the prayer for dismissal of.
Mr. Nawaz, what is wrong? Why should why this re-examination is not allowed? Because this is not a case where they want to fill up a lacuna,
Yes, ma'am.
right? Here it appears that subsequently another certificate has been
Yes.
obtained which shows 1999.
Yes, my lord.
There was
This
nothing.
order is otherwise not correct, my lord. Fairly submit, my lord.
Mhm.
And it is rather unfortunate, my lord, that the victim of the case had to come
Died.
before this honorable court and obtain a stay, and the stay has been operating for 6 years. Otherwise, this is cannot be termed as filling up of the lacuna, my lord.
Correct. It's
If
not
there's a
filling up
document-
lacuna,
Yes, ma'am.
and plus 311 can be exercised at any stage of the trial.
Yes, my lord.
Here the argument, it was at the argument stage.
Yes, my lord. And
They will get an opportunity to cross-examine.
Correct. No one is going to be prejudiced. On the other hand, by ignoring this certificate, which shows that the date of birth is 99,
exactly.
this is absolutely palpably erroneous.
This is absolutely wrong order. And the ground, my lord, which has been given, that there's a possibility that it may be a manipulated document, they will get an opportunity of
That is-
cross-examining. Trial court, my lord.
311
Yes, ma'am.
that can be
Yes, yes.
decided.
In fact, on this issue also, the Supreme Court has settled the law that if there is some cogent evidence which can be collected, that cannot be termed as filling up with the lacuna. I have a judgment on this point also.
Yes, Mr. Locker, anything?
Also can dispose of that. Otherwise, since 2018, Lordship, it is pending, Lordship.
Very sad. These
Yes.
cases are pending for such long time for such small things.
And because of that order, this order, Lordship, they have
No,
getting justice.
Justice.
Till later.
I've been told that
Very
the
sad.
victim has died also, committed suicide.
Very sad state.
Para 7 onwards, my lord, the judgment is very clear.
Para
7, my lord. Seven and 8, my lord, they're available.
Yes. This is item
26.
Heard Mr. Z. Alam, learned counsel for the petitioner. Stop. Also heard Mr. S. Nawaz, learned amicus curiae. For respondent number 2, and Mr. P.S. Lawcore, learned APP for the state respondent. Stop. By way of this petition, under section 482, read with section 401 of CRPC 1973, the petitioner is challenging the impugned order dated 30/8/2018, passed in session case number 70 of 2017 by learned additional session judge FTC number 4 Kamrup M, whereby the prayer of the petitioner for re-examining
PW1, madam.
for re-examining
The
the
petitioner is
headmaster Sunitpur Lower Primary School as court witness, and also for directing him to produce and to exhibit the admission register, and also to produce an extract copy of the relevant page of the admission register, was rejected. The facts of the case is that
you will find it at page 3, para 3.
that on 12/5/2015, respondent number 2 lodged an FIR.
Respondent number 2 is the accused.
Sorry.
PW2.
Sorry, you are who
I'm
is
PW1.
Sister Siba Anthony PW2 is who?
Informant.
The informant stroke PW2 lodged an FIR against the
Respondent number 2.
respondent number 2 stroke accused, alleging inter alia that by way of impersonation, the accused misrepresented himself as brother of the victim and fraudulently kidnapped her. Stop. Accordingly, an FIR was registered, a case was registered, being Gorchuk FPS case number 248/2016 under section 419/366 IPC, 366A, IPC. Stop. Thereafter, the investigating officer investigated the case and submitted charge sheet against the respondent number 2 accused under section 419/366 capital A 376 IPC, and thereafter the court of session judge took up the case for trial by framing charge under
Section 366.
under section 366 A.
No, only 366.
366
Because
IPC.
no birth certificate was available.
Madam, one more thing, madam. It would be learned additional session judge number 4 FTC Kamrup.
Learned court of additional district and session judge number 4 within bracket FTC Kamrup M, Guwahati. Thereafter, prosecution adduced 6 prosecution witnesses and after completion of the evidence, the petitioner filed a petition under section 311 CRPC with a prayer to re-examine the PW1 was the headmaster.
No, he has not been examined.
To
examine-
allow
examine.
to examine the headmaster of Sunitpur Lower Primary School, Kamrup M, Guwahati.
Santipur, madam.
Sorry, Santipur, huh? Santipur Lower Primary School, Kamrup M, Guwahati, as a court witness. However, the said petition was rejected by the trial court by order dated 28/2018, situated thus the aforesaid criminal revision petition has been filed. Mr. So-and-so Alam, learned counsel for the petitioner, submits that the order of the trial court in rejecting the application for examining the headmaster is palpably erroneous, inasmuch as in view of the discovery of the certificate issued by the concerned school indicating the age of the victim, indicating the date of birth of the victim, year of the birth of victim as 1999, it has become imperative to bring the said evidence on record in the interest of justice. Stop. Correct?
Not this.
Mr. S. Nawaz, learned amicus curiae, as well as Mr. So-and-so Locker, learned APP, also fairly submits, no, first the Locker ko banalagay, Nawaz, fairly submits that since additional information as regards the age of the victim has come out during the after the closure of the evidence, it was imperative for the trial court to allow the examination of the headmaster as sought for. In support of the aforesaid submission, he fairly relies upon the decision of the Apex Court in the case of Rajendra Prasad versus Narcotic Cell, reported in 1999, 6 SSC 110. Mr. So-and-so Locker, learned APP, also fairly concedes that the application for examination of the headmaster who appears could have thrown light to the correct age of the victim ought to have been allowed by the trial court.
Same is the deciding factor of the case.
Which being the deciding factor of the case in hand. So, heard, perused, diba? Apt to reproduce the relevant portion of the application filed by the petitioner for examining the headmaster, which is reproduced hereunder for ready reference. Paragraph 3, paragraph 2 to 7, page 19. Reading of the aforesaid application, it is apparent that after the PW1 was examined, at the time when the PW1 was examined, the certificate, the school certificate of the victim girl was not available with him. It is further apparent that subsequently on 22/3/2018, the PW1 stroke petitioner procured the said certificate, from where it appears that the victim was born in the year 1999 and not 1998, as deposed by him during his examination in chief before the trial. It appears that the trial court, by order dated 28/18, rejected the said application the operating portion of the aforesaid judgment order of the trial court is reproduced hereunder for ready reference, quote unquote, para 5 and 6. I think 5 and 6 is sufficient.
Yes, madam.
5 and 6, A to A, page 23. Reading of the aforesaid order of the trial court, it is apparent that the trial court rejected the application for examining the headmaster only on the ground that the petitioner is trying to fill up the lacuna in the case of the prosecution, and therefore there is no cogent ground to allow the said to fill up the lacuna in the prosecution case. Go full stop, quoted. Stop. It is apparent that it appears that the ground for examining the headmaster of the concerned school is to bring on record the correct age of the victim, which is a decisive factor in the case in hand, as the school certificate indicating the age of the victim was not available with the petitioner at the time of deposing before the trial court. That being so, it cannot be said that the petitioner is seeking examination of the headmaster only to fill up the lacuna in the case of the prosecution. Apt to refer to section 311 of the CRPC, which reads as hereunder. It is crystal clear that the quote unquote, it is clear, it is a reading of the aforesaid. It is crystal clear that the court has been empowered to summon any person as a witness at any stage of inquiry, trial, or other proceeding. Where essential. Stop. Reference in this reference is made to the decision of Rajendra Prasad Supra, paragraph 7 and 8 is reproduced for ready reference. wherein the apex court have held that oversight or mistakes during conducting of case cannot be understood as lacuna and so can be corrected in exercise of powers confined under section 311. Stop. Quote unquote to Koridiba, para 7 and 8. Reading of the aforesaid, it is clear that no party in a trial can be foreclosed from correcting errors. Stop. That being so, I am of the considered view that the trial court has committed a palpable manifest error in not allowing the prayer of the petitioner for examining the headmaster, and therefore the order of the trial court is liable to be interfered with. Accordingly, accordingly the order dated so and so Koridiba is hereby set aside. Resultantly, the application stands for examining so and so stands allowed. I think that can be ordered.
Yes, madam.
Or should it go back to the
No,
court?
no, Lordship can allow it.
If
They have
you-
to call that witness.
Any trial court record আহিছিলে নেকি ইয়ালে? কি হয়? Upon producing the certified copy of this court's order, let the said witness be called for examination by the trial court, and upon examination, an opportunity to cross-examine the said witness be also provided to the accused respondent, and thereafter proceed in accordance with law.
Deeply.
Disposed of.
I'm deeply obliged.
This court appreciates the assistance rendered by Mr. So-and-so amicus curiae, and directs who pays the registry, and directs the registry to submit citing and amount. Any idea what is the amount that is given nowadays?
No, madam, never claimed, so I don't know.
No,
madam.
you will not claim, but why will we not give it? And
I'm deeply
I'll
obliged.
fix that.
Well, I'm deeply obliged.
Yes, hold it, huh?
27.
May I please, Your Lordship? My lord, for last 3 days, my lord, I was out of station, my lord. I had some personal difficulties, my lord. And in fact, the petitioner, my lord, he is also not in touch with me, my lord. Now, she will kindly fix this case in the first week of, my lord, April, my lord. In the meantime, I'll get the instruction.
Of April?
But I have some difficulty in the last part of the, my lord, March month. That is my lord.
You want accommodation for today, this court will give you.
My lord.
But this court is not going to post
Then,
this
my lord,
2018
in the next week, my
matter
lord.
to
In the next
April.
week, my lord, the last, my lord, on
Next
next Thursday.
week.
Next
You-
Thursday, my lord.
Yes, you make yourself
My lord.
convenient.
Lordship, I don't have any. My only grievance is that, Your Lordship, on earlier occasion, that is in 6/11/2019, this honorable court Lordship has passed an order to pay 5,000 as
That's not
maintenance.
paid.
Only 1 or 2 occasion they have
That has to be
paid.
confirmed, my lord.
That
He's not in
he
touch with
may
me, my
bring
lord.
the
He get it
instruction, Your
instruction.
Lordship, and also
MS,
area payment. Your
MS
Lordship.
MB Borua, Learned Counsel appearing for the respondent, submits that despite this court's direction by order dated 5/12/2019 to pay the interim maintenance.
6/11/2019, Your Lordship.
No, order dated 6/11/2019 to pay the interim maintenance of 5,000, comma, the same is not regularly being paid.
And also the arrear, your lordship. The order is given, your lordship, regarding the payment of arrears. Though she has filed a petition before the honorable court.
All right, that is okay.
Okay.
Mr.
Z. Hamad.
Z. Hamad, learned counsel for the petitioner, seeks accommodation to obtain instruction in this regard. Prayer is allowed. List on Thursday, date to date.
27. Please.
Much obliged.
What? Aisa.